两公约第4次国家报告
The International Review meeting of the ROC's fourth report begins. This is the fourth review meeting, and this is the second session, and we'll review Articles 2 to 5. Please make sure that you do not speak too fast for the benefit of the interpreters. And also, when you speak, please identify the organization that you are representing.
Okay, good morning, 大家好. Thank you for coming to this. I think this might, okay. Thank you for coming to this fourth review of the international implementation of the International Covenant on Economic, Social, and Cultural Rights. I thank to the government of Taiwan for having this constructive dialogue regarding the articles of the ICESCR. And also I recognize that there are NGO representatives also listening to the dialogue. And then after this 3-hour session this morning, we'll have a separate session with the non-governmental organizations. We are still missing Mr. Olivier de Schutter, who arrived just early morning yesterday. So he's still coping with the time difference as well as exhaustion from the long flight. And hopefully he will be arriving soon. From yesterday's experience, I think it would be really not comfortable for all of us sitting for 3 hours straight. Yeah, so I would like to suggest that we have 10 minutes break in between. So after 1.5 hour session, we'll have a 10-minute break and then resume the rest of the morning session with the government representatives. Would it be okay? Right, thank you. Yeah. So for this morning session, we will deal with from Articles 1 to 5 of the International Covenant on Economic, Social, and Cultural Rights, which covers the common elements regarding economic, social, and cultural rights. And I would first ask Mr. Jochen van Bernstorff to speak.
Thank you. Good morning, everyone. I would like to address the issue of indigenous rights and in particular the status of the so-called Pingpu in this legislation from the government Pingpu people. First of all, I would like to acknowledge the progress that has been made in implementing the Constitutional Court judgment that required the recognition of the Pingpu people. In the submissions received, we saw that there are still some unresolved issues. And my question would be, what concrete measures exist to guarantee full equality of Pingpu peoples in law and practice, despite the status or the standalone legislation we have now, which actually recognized the Pingpu peoples, but which did not provide concrete rights. So there is a concern that they may not have the same rights as other indigenous peoples, and I would like to know whether there are concrete measures or concrete timelines also, whether they exist, which will guarantee the full equality of Pingpu peoples.
Thank you. Yes,
Yeah.
please.
谢谢。那这个
Thank you. So I would like to ask the Council of Indigenous Peoples to respond. Chairman, ladies and gentlemen, dear colleagues, good morning. I would like to thank the review member for the question. The Pingpu indigenous peoples have received a lot of international attention. So the Status Act identifies the indigenous identity, so to speak, but the law doesn't cover all the rights. In terms of history, the Pingpu indigenous peoples have a different history from other indigenous peoples. That's why currently we only have the Pingpu Indigenous Peoples Status Act. In fact, the rights of indigenous peoples currently are scattered across many different legislations. For example, land and also culture and languages, all these protections are scattered around different legislations. So for the Pingpu indigenous peoples to be sure that there can be clearer resource input and rights designation. In Taiwan, we now have the Pingpu Indigenous Peoples Status Act. And we at the Council of Indigenous Peoples have to take inventory of all the resources within 6 months. We have to take inventory of all the relevant provisions that have to do with indigenous peoples. And we also have to think about how to design a regime so that the Pingpu peoples can also enjoy the same rights. And the law says that within 3 years, we also need to devise another law to protect the rights of the Pingpu peoples.
You have any follow-up question?
Yeah, thank you very much. So I understand that the new legislation is being prepared that will guarantee then an equal status of the Pingpu peoples. I have another specific question on the not only not referring to the Pingpu peoples, but to indigenous peoples law in general. A very specific question regarding the regulations for consulting and obtaining the consent of indigenous peoples. This, from the submissions we received, we saw that there are some problems with regard to certain mechanisms of, they're called, I think in English, of administrative proxy, convening of tribal assemblies through administrative proxy, so that the administration actually replaces the deliberations and the decision-making processes that should take place within the indigenous communities. And this mechanism of administrative proxy, I think, was also criticized in a judgment by by an administrative court, and we're wondering whether this is being revised, this regulation, or whether the government has taken measures to revise this legislation or this regulation for consulting and obtaining the consent of indigenous peoples. So it's a problem of free, prior and informed consent. And from the submissions we saw that there are some concerns there with regard to this specific regulation. Maybe you can enlighten us.
Yeah,
on
please.
that.
好，那
Thank you for your question. So regarding the proxy convening system, the regulations for consulting, originally, it's the tribes themselves that have to notify the residents to attend the consultation meetings, and over half have to give their consent. But sometimes tribal chiefs, for whatever reasons, don't convene these meetings. But certain applicants have a timetable to keep. So that's why our regulations for consulting and obtaining the consent of indigenous peoples and communities for participation has the proxy convening system. Now, tribal chiefs, they are civilians, so there's no way for us to force them into convene the meetings. Let's say if an applicant has a land development project, they do have a timetable to keep. That's why we have the proxy convening system, where the local township office can convene a meeting on behalf of the tribal chiefs. But that only means that the township offices will notify the residents. So basically, you still need tribal residents to give their consent. So this proxy convening system doesn't take away the decision-making power of the residents. The regulations for consultation and obtaining of the consent, obviously, people have different voices and opinions regarding the regulations. So we are still talking to stakeholders, and we are now working on revising the legislation.
Thank you very much.
Yes, thank you for that. I just wanted to ask a follow-up question. In part to the National Human Rights Commission, because you've also provided us with very good information and an analysis of concerns about regulations on consultation and consent. And so I see from one of our submitters, the Environmental Rights Foundation, one of the points they highlight is that under the present draft, a single person can raise an objection, and they say this essentially grants any single person the power to veto an entire tribal charter. And so my question is, do you recognise that needs to change, to the Council of Indigenous Peoples, but also to the NHRC? I wonder if you might provide us with your view about the current draft of the regulations. And I also wanted to ask, does the National Human Rights Commission engage with the Council, and does the Council of Indigenous Peoples, do you engage with each other? Do you discuss issues? Do you draw on each other's knowledge and experience in the work that you do for Indigenous peoples?
Would you like to give some advice from the perspective of National Human Rights Commission regarding Indigenous peoples?
是不是？主席，我们是不是？
Can we have representative of CIP to answer first? Council of Indigenous People to answer first. Thank you. For the human rights of indigenous people, we have the NHRC in Taiwan. We also have representatives here in the commission, in the NHRC, to speak for the rights of indigenous people. In CIP, we also have a indigenous people rights task force, and we hold regular meetings to voice for the rights of indigenous people. Thank you.
那
Is there
请问
anything you want to add?
人权会有没有要补充？
So, NHRC, do you want to add any information? So I think people still have some, so is this about the FPIC? Is this a question about FPIC? Well, the chairperson was asking, so a person has a right to deny.
Okay.
So two aspects of it. One is you provided us with information on the National Human Rights Commission's concerns about the current and draft regulations on consultations and consent. And so I just wanted to ask whether you wanted to highlight any of those concerns that we should take account of. And the second aspect of my question was, does the National Human Rights Commission and the Council for Indigenous People, do you work together, do you consult each other, do you discuss issues together, given the importance of Indigenous rights issues?
So FPIC, I can give you some example. For example, in terms of the land, we can see the township office will convene. And is it good for the tribe to convene? It's not one person can deny it all. And the township office, afterwards, they will send it to the county and the city government, and they will send the proposal, the plan, to the CIP. So not one person can have a veto right. So that's the content about the FPIC, about the regulations for obtaining the consent. So for CIP, I want to add some information. So in terms of convening, actually, this is not the township office doing the convening. Actually, the community, the tribe chief will convene a consultation meeting. So if there's a majority vote for approval, if you have the right, quorum and over a majority vote, and then this will be deemed as approval. So not that one person can have a say to make the decision. It doesn't need to go through different layers all the way to the CIP for final approval. On the side of the consultation meeting, if the decision is approval, and then that means this is approval, CIP cannot have a final say. So we need to respect the opinions of the tribes. In terms of the collaboration between the two organizations at NHRC, we have our representatives from the CIP to voice for the rights of the indigenous peoples. I would like to respond. I think there is a difficulty here. So for example, for the township, if the decision is approval, we wonder whether they are affected. They are under the pressure of the large companies. For example, there is a hydropower plant in Taichung about the establishment, the development of the power plant. So we are worried whether the tribes are under the pressure of the groups of the large companies. So that's why we ask the Taichung government, the township, to play a role. So that is a difficulty in PFIC. So we shouldn't just get the consent from the local level. We need to send the submission all the way to NHRC, to the Control Yuan.
Clarifications. That's helpful. Thank you.
I'm afraid I'm still confused because the lady representing the Council of Indigenous Peoples, yeah, you said first the meeting is convened by the township offices. And then you said that actually it's not convened, the chiefs, tribal chiefs convene the meeting. So what is the fact? The notification is by the township offices, of course that can be, but you also mentioned that because of the time program, etc., rather than the chief, the township offices convene the meeting, and then people, indigenous peoples, attend the meeting, and then the decision is by majority. So can you please explain?
Let me respond first. So CIP said it right, but the reason I add the information is because at the township level, they think the decision is approval, but actually lots of people, lots of residents, indigenous people still oppose. So we can see there's a discrepancy between the township and the tribes. So because of that discrepancies, so that actually the proposal is sent to the Taichung city government for final decision. So according to current rules, CIP said, yeah, everything is done, is decided by the local tribes. However, if there's a difficulties, we want to advance to a higher level to, for example, the city and the county CIP for final decisions.
Yes, for the explanation, please.
谢谢。
So the NHIC representatives say that for consultation, sometimes there are difficulties. For example, for the applicants or local governments, they may have differing views. So actually not recently, we have been working on this for a long time. We hope that the regulation on obtaining the consent can meet the expectations of different aspects.
So when do you expect the draft regulations to be finalised? The regulations that need to be developed following the Kana Luvang solar energy case. I understand that that case in the TCC incinerator case required the regulations to be updated to meet the decisions in that case. Are the regulations on consultation and consent, are they being updated, and when would that be done?
Okay, let me respond. For the regulations for obtaining the consent, it has been announced. Because the Executive Yuan pays a lot of attention to this regulation. So we will report to the Executive Yuan first. So afterwards, we will promulgate, we will implement this regulation. But prior to that, we need to rely on our current regulations.
It is important that in order to realize free, prior, informed consent principle, I think the indigenous peoples themselves really should feel that they give consent with free, prior, and informed format. Yeah. So maybe in your new regulation, you need to take into account the opinions of the indigenous peoples themselves. And then if it was pointed out that sometimes there is discrepancy, that indigenous peoples' situation and decisions contradict the wishes of the people, residents in the larger township. So I think that in that case, if the residents in the township, which encompass the area the indigenous people live, are different, then the problem arises. And I think indigenous peoples themselves are asking, they want to have autonomous administrative decision power, yeah, which we call administrative proxy, performed by the township offices. So I think that there's some conflict of interest in terms of decision making, in terms of autonomy, in terms of real consent and decision by the indigenous peoples. I hope you understand what I'm saying.
谢谢主席哈。那其实我们至少
Actually, in our regulations for obtaining the consent, in addition to getting the consent, consultation is also very important. For an applicant or for a developer, you need to have a lot of briefings so that the community, the tribes, will know how it's going to impact the community, so that they can exercise their right of FPIC. They need to know what is the impact on their community. And if they think it is okay, then we will have a final meeting. And for township office, they act as a proxy for the procedures. They do not interfere with the final decision. So we really care about their right of FPIC.
Is there any? Okay. Yeah. So we are then done with the issue of indigenous peoples, which you want to add something regarding this issue? Okay. Mr. Milun Kotari. Yeah.
Yeah, good morning, everyone. I had a question about the following Typhoon Morakot in 2009. Our understanding is that the Taiwanese government initiated a very large-scale post-disaster relocation policy. The policy resulted in large-scale displacement, and the indigenous communities were, the reports say that they didn't have enough time and were moved far away from their original territories, while the contractual arrangements and relocation policies significantly limited their ability to return or continue land-based livelihood. So the question I have is, has the government of Taiwan established a human rights-based post-disaster reconstruction framework to prevent, the type of situation that happened here? And how does, in that context, how does the government ensure that it's not only a question of providing resettlement, but that indigenous people's land rights, cultural rights, and so on are respected? This is related to FPIC, but I think particularly on the post-disaster situation, I just wanted to know more what the government is doing, because this is something that unfortunately may happen again. Thank you.
Who's going to answer?
So I think I'll first ask the representative from the CIP to respond, and the representative from the Ministry of the Interior will add more information. Thank you. Thank you for your concerns for indigenous people's rights. Typhoon Morakot, of course, had a huge impact on our indigenous communities. And that time, the government, I think, set up a temporary post-disaster recovery commission. And the commission was in charge of dealing with all sorts of post-recovery issues. And the Commission actually brought together resources from different ministries and agencies in the central government. There were discussions as well, and representatives from the disaster-stricken communities were invited as well to talk about recovery work. And at that time, the affected area was very big. So if you want to stay in the original area, in fact, it would be very difficult because it could still be dangerous. That's why there was no way for us to relocate the communities to nearby areas. That's why we decided on other locations. But this was after discussions with indigenous communities. Of course, I think it's difficult to satisfy everyone, but we tried our best to do right by the most number of people.
Yeah, thanks very much for your answer. I think the question that comes from the information before us is that the communities were moved. You say they could not be moved nearby, but they were moved very, very far away, and lost, their sacred, connection to the land. They lost their livelihood, and so the question was not so much only on the post Morakot situation, but generally what are the steps the government is taking to ensure that a similar situation does not arise, where, in a sense, people are forced to move away from it. What I'm asking is there prevention work that is taking place so that there's adaptation, there's, so that these kind of situations do not arise. So essentially what we need is a human rights-based post-disaster policy which takes into account all the climate change concerns. Thank you.
Like to respond for that?
The CIP, please. Or perhaps I can pitch in.
And then you can go ahead, please.
So from the CIP's point of view, of course, if you want to relocate a whole village or community, it actually involves many different agencies. If we are talking about land, usually we relocate communities to government-owned land. That's why you have to talk to the government agency responsible for state-owned land. And we also need to talk to other agencies about what government land is available for relocation. So for us, we, the CIP, is more like a coordinator in this process. And we also have to talk to other government agencies, and we try to act in accordance with the interests of the indigenous peoples. But unfortunately, it's not entirely up to us to make certain decisions. So certain indigenous communities may be relocated to faraway areas. And if that's the case, then we'll try to come up with measures regarding employment, healthcare, and we will also set up a center bringing together different government agencies that will address the problems encountered by the relocated tribes. Well, regarding the future, I think, well, basically we have a government mechanism which is like a disaster prevention mechanism, and it's also a platform for us to talk to each other. And when necessary, the government will come up with certain measures that will provide resources and funding to affected communities, especially regarding a post-disaster recovery and employment.
人权会要回应。
In HRC, so I just respond very briefly. I'm very happy to see that you are still following up on the post-disaster recovery from 16 years ago. And at the time, the principle was that communities should be kept intact and relocated in the same township. But the problem is that the indigenous communities cannot go back to where they used to live. So in a way, you can say that this is a form of forced relocation. So the indigenous peoples have to change their household registration, and they cannot even go back to their original community for example, burials and so on. But after Control Yuan investigations, the original regulations were abolished. So I think after Typhoon Morakot, the way the government does things would change.
Is there any additional replies from the Ministry of Interior?
The Ministry of the Interior, any additional comments? If not, I think that's it.
Thank you very much for the extensive replies to the question on indigenous peoples. I think that deals with Article 1 on self-determination, as well as Article 2 on non-discrimination regarding indigenous peoples. Now we will deal with other aspects of Article 2, and Mr. Olivier de Schutter will talk about first maximum available resources.
Yes. Good morning. Many thanks, Madam Chair, for providing me with the opportunity to raise, in fact, two questions related to Article 2, Paragraph 1 of the Covenant. The first question I have relates to question number 9 in the list of issues that we proposed in advance of this interactive dialogue with respect to the implementation in Taiwan of the guiding principles on business and human rights. I understand that consultations are taking place on the National Action Plan 2.0, the second iteration of the National Action Plan on business and human rights. Can the authorities explain whether the draft that is under discussion intends to include a human rights due diligence obligation imposed on corporations to monitor compliance with human rights in the supply chain, as recommended in the Guiding Principles on Business and Human Rights of 2011. I understand that for the moment, the legislation does not include such a human rights due diligence obligation, but is there a plan to introduce such?
The Ministry of Economic Affairs, please. I'm from the Ministry of Economic Affairs. So regarding the Taiwan National Action Plan on Business and Human Rights 2.0, especially in the second pillar, respecting human rights, we do hope that we do hope that enterprises can carry out due diligence. However,
Okay, thank you.
However, currently we are assisting companies to build capacity to carry out due diligence. So we are still monitoring international trend and social consensus before we introduce the obligation.
Thank you very much for this confirmation, and we look forward to seeing the results of those discussions. The second question I would like to raise relates to the 10th item on the list of issues that we proposed for this interactive dialogue concerning the requirement under the covenant to dedicate the maximum available resources to the realization of economic, social, and cultural rights, which essentially means that the government is expected to use whatever resources it can mobilize through taxation, through imposing royalties for the exploitation of natural resources, through import and export tariffs and so forth, to fund the realization of economic, social, and cultural rights. And the answer of the government was extremely detailed and helpful about the evolution of the tax rates and the spending on education, healthcare, social housing in particular. The one question that does remain is related to the overall tax burden that Taiwan applies. Now, if you include social contributions for insurance, social insurance policies, in other terms, if you combine taxation and social security contributions, you arrive at a rate that is around 21% of the GDP. And that rate is lower than the rates that we find in comparable countries, including South Korea, where the rate is 25.3%, Japan, where the rate is 33.7%, or many OECD countries where the rate is around 30%. In fact, in many European countries, it's around 35 to 40%. And so the question is very simple. Is there any intention, given that the economy of Taiwan is doing well, to gradually increase the levels of taxation and social security contributions in order to fund, in particular, social assistance schemes that remain insufficiently protective of individuals in poverty? So that's my question. It's a general question about the assessment that the government makes about the possibilities to have a more progressive taxation system in order to fund the realization of economic, social, and cultural rights. Thank you.
Thank you for the question. So this is regarding the overall tax rate and social security contributions, whether we can have more resources to realize economic, social, and cultural rights. So I'd like to ask the representative from the Ministry of Finance to first respond. And the reviewer also mentioned the poverty issue. So I'll also ask a representative from the Ministry of Health and Welfare to respond.
Okay, thank you. Thank you for the question. Like you mentioned, for the tax rate in the share of GDP, because it has to do with two aspects. First, about the tax percentage. Second, you talk about social security contributions, and social security contributions include labor insurance and the national pension and also the national health insurance, because this part has to do with other agencies. So we need to look at how other agencies are responding to this. So I will finish my part first. From the Ministry of Finance, we only talk about the tax income, because for our tax policy, we focus on using, light burden tax in our policy, and also in response to our economic development, social development, and environmental development policies, we take appropriate measures to decrease tax collection, to encourage people to make more consumption, to encourage companies to make investments, and also to create more job opportunities. In the past, without social security contribution, the tax rate in account for GDP is about 12 to 13%. But because our economy is developing very well, and then people are making more and more money, and recently we are increasing in the tax amount that we collected. So for our tax burden, without social security contribution is on the increase to, for example, 14.6 in 2014. And then in 2015, we can see the total tax collection amount is increasing. But in our calculations, we can see the nominal GDP is also growing. That is why you see that tax as a percentage of GDP is decreasing. This is not because the absolute amount is decreasing. This is because our nominal GDP is also on the rise. So all in all, you can see in our tax system, we can see the tax burden ratio is increasing. And we're also reviewing our tax system so that we will have enough tax to work as a funding for the government's implementation. And the tax burden ratio reflects our tax burden of the people, but the percentage doesn't mean the situation of our finance. It doesn't represent our international competitiveness in terms of the national debts. So we cannot only compare the tax burden ratio. We also need to compare, for example, the national incomes. So I think our tax burden ratio is in a reasonable range, and our tax collection are able to help the company and meet the country's needs for economic development. In terms of the reasonableness of our tax system, we're also reviewing on a rolling basis. And we also look at the international development to expand our tax collection so that we can make sure that the country can have sustainable funding. So the Ministry of Health and Welfare, good morning. For the Ministry of Health and Welfare, in terms of tax and poverty, I would like to respond to that issue. First of all, I want to thank your concern over this. Now in Taiwan, we are actually amending our Public Assistance Act. And lots of organizations are proposing other countries' references. But we need to, of course, look at the government's budgets to think about the income and expenditures. And you talk about the social security contributions as a percentage of GDP. So without social security contributions, the Ministry of Finance, we can see in 2024, our percentage is 14.7%. If you look at the UK, the number is 28.6%. So in terms of, social assistance and the standards, we need to look at the government's capability and affordability. And yesterday, I heard from my colleague saying that yesterday you talk about poverty rate and people in need. In addition to refer to the OECD's definition on poverty. And then we see countries in terms of their public assistance system. In addition to OECD poverty, there are also other requirements, for example, for real estate or movable assets. There are some definition to define who are the people that we want to help. So this time, during our amendment of the Public Assistance Act, of course, we want to relax some requirements so that we can expand our coverage to help disadvantaged people. So in addition to evaluating people's needs, secondly, we also evaluate the country's financial capabilities. And then we are looking after the relaxation of standards. What is the funding gap that will be needed for follow-up measures? So we need to consider all of that. So in terms of taxation, of course, we need to follow the Ministry of Finance in terms of planning and renovation so that we will have more funding to carry out our assistance. So from the Ministry of Wealth and Health, so in 2020, we put in 2.37 trillion US dollars in the total society coverage and protection. And then we can see in 2024, the number grew to 2.69 trillion. So without taxation policy being changed, the government still continue to invest in social coverage. So we can see for the COVID-19 budget, after the budget was withdrawn, and then actually we continue to put in more budget to take care of the society.
Yeah, thank you for the replies from different ministries. Is there any other issues that you want to raise under equality and non-discrimination regarding any other group of population? Okay, then we go to Article 3, equality between men and women in the field of all economic, social, and cultural rights. And for that, I will raise questions. In our question number 11, there was a question regarding the forms of gender discrimination in the workplace and analysis of the root causes of gender discrimination in Taiwan and measures to eliminate them. And the answers we got is about Gender Equality in Employment Act in general, what it prescribes, what forms of gender discrimination, what are prohibited, etc., but didn't come up with concrete answer. What is the most prevalent forms of gender discrimination that complaints are submitted on, and root causes, there is no answers. Yeah? So I would like to ask it in different forms. First, there is a mention about gender equality in Employment Act, which I think is good. In general, it prohibits any form of gender discrimination at workplace, you know. So, but in the replies, the complaints and confirmed cases, number of complaints and confirmed cases of gender discrimination has been increasing. For example, in 2020, the number of complaints submitted was 137, and then confirmed cases out of that was 29. In 2024, the number of complaints have almost doubled to 250. So from 137 to 250 in 4 years. And then also the confirmed cases of gender discrimination was 56. So it was almost doubled from 29 to 56. So how do you interpret this increase? Is it because there have been more cases of gender discrimination at the workplace, or is it because more women are now conscious of the discrimination at the workplace, and then the reported cases are, or complaint cases are increasing? What is your analysis of this phenomenon of increased complaints and increased confirmed cases of gender discrimination? And what are the most prevalent forms of complaints of gender discrimination that complaints was submitted on? So who would like to answer this question?
好，谢谢。
Thank you. So the Ministry of Labor will respond. The Ministry of Labor representative. According to the Gender Equality in Employment Act, in terms of complaints, according to our statistics, we can see the most complaints come from recruitment. And also, we can see the second one is layoff and termination. So for the employer, for the applicant, if they think the applicant is going to get pregnant and give birth, so that during the interview process, the applicant may be denied of the opportunity. Or if the woman started working for a company and this woman got pregnant, and then the employee may ask the pregnant woman to leave or terminate her job. So that is the most prevalent, violation. I think the root cause is because employers have this stereotype for female workers. Because we can see that culturally, women are believed to be the main caregiver and to take care of the family, take care of the children. So that is why women are, compared to men, are more likely to be discriminated against their gender. So the government values the Gender Equality in Employment Act, so the government is making a lot of promotions and organizing seminars. Also on Facebook, we also make videos using YouTube, using this kind of channels to beef up our promotions. We want to encourage general public's awareness on, gender equality in the workplace. I think the reason that the number of complaints increased is because, after the government's efforts and promotion, people start to realize their benefits and their rights, and they know that there are more, channels for complaints. So I think that is one reason contributing to the increase of number. And then in 2024, actually, for these past 2 years, we continue to make more efforts in terms of pregnancy discrimination. I think that constitutes one of the most severe violations. if a pregnant woman leave the workplace because of pregnancy, it's going to be very difficult for her to return to workplace because this woman may be trapped in the family role. So starting from last year, the government has done a lot of efforts to reduce pregnancy discrimination. For example, on our Ministry of Labor website, for this kind of violation, we asked the city and county governments to mark this kind of violations. And there's a dedicated section on the website saying what are the entities, companies that have this kind of violations. We also work with the Legal Aid Foundation. So starting from this year, we will provide a conference service, video conference services, so that the lawyers will provide this one-on-one consultation in a highly private environment to serve these female workers. Because some females may worry about making complaint directly to the government. So now we have this hotline, we have this video conference hotline for them. Thank you.
Thank you. What about sexual harassment at workplace? Is it also the subject of complaints, and then frequency in terms of how often it happens?
Sexual harassment is also covered by the Gender Equality in Employment Act. So sexual harassment cases, of course, victims can also complain, and they can also use our legal aid service. So when you say frequency, do you mean the frequency of using the service or the frequency of other things?
Complaints, you said that pregnancy-related complaints are the most prevalent form, and then sexual harassment in terms of forms of gender discrimination. Is sexual harassment a criminal charge, or is just a administrative fine?
So in 2024, if we look at the 2024 data, sexual harassment cases actually outnumbered other sexual discrimination cases or gender discrimination cases. In the Gender Equality in Employment Act, the employer has the responsibility to prevent such offenses as well. So usually we use administrative fine. However, if an act is basically a violation of criminal law, then of course it will become a criminal case.
You say that in 2024, sexual harassment is the most prevalent form of gender discrimination happening in the workplace, rather than it's much more than the pregnancy-related one.
Yes, that's right. So the highest number is actually sexual harassment-related complaints. So it could be that the employer doesn't have prevention measures against the sexual harassment, because employers actually have the responsibility to have such preventive measures, and they have to publicize the preventive measures. And also it could be that employers become aware of sexual harassment and they have to take remedial actions. And of course, there are also actual sexual harassment happening in the workplace. So these are the typologies.
Yes. So we can go back to your earlier analysis of what is the root cause of it. So you said pregnancy-related discrimination is because of the stereotypes that it is woman's role to take care of the children and family, etc. What about sexual harassment cases? Is it also related to the stereotype, or how do you interpret this spite of all the efforts that Taiwan government is now taking measures to change the situation, you know.
I think, I guess we are still trying to analyze what the root cause is. I think when the law was implemented, then people paid a lot of attention to sexual harassment. But of course, I think we have to continue to raise awareness about this issue. It's just that there are probably a lot of companies that are still not very aware of the legal provisions.
Yeah, I think we need a deeper analysis of how to change that, how to change the working environment for women, as well as the social stereotype. Would you like to respond?
So, according to our Gender Equality in Employment Act, in fact, there are certain specific typologies. There is, for example, a more powerful person committing sexual harassment and so on. Maybe you can provide more information. Okay, so I'll provide more information here. The Gender Equality in Employment Act prescribes 3 types of sexual harassment. So first of all, it's a hostile work environment. So when a person carries out his or her work, then they are faced with something with sexual innuendo. And the second type is some kind of exchange. So for example, the employer wants the employee to give something, and this is sexual in nature. So for example, I'll give you better performance review if you give me something. And there's a third type, which is someone in a more powerful position committing sexual harassment. So these are the 3 major types. And in terms of our sexual harassment related provisions, we constantly look into them and revise them. And regarding the highest responsible person of a company, I think previously the law provisions were not detailed enough. So there were cases where the people who are responsible were not covered by the legal provisions. But now we revised the regulations to broaden the definition of the so-called highest person responsible for a company.
But I guess sexual harassment can happen by the person superior to you, or by the colleagues, or even by the customers, you know, of the company. So it can happen by anybody, and sometimes it can also happen by women against male employees, you know, in case of who are in inferior positions. So I think we need to really analyze the various situations and then try to prevent it through the changing working environment, and then through the change in the consciousness. Anyway, so there is more room to improve the situation in terms of gender discrimination at work. But the International Covenant on Economic, Social, and Cultural Rights prescribes that the state should ensure that women enjoy the equal right in all economic, social, and cultural field. You know? So it's not only at the workplace, but in the family, also in the society in general. So you also pointed out that there is stereotype, and then you are trying very much through seminars and then Facebook, etc. So my question related to changing the stereotype about gender role, you know, that women play this role and men should play this role. So is there any survey, for example, to check how these gender role stereotypes are changing over the years? Do you do it regularly regarding whether there is any change of consciousness about this stereotyping role played by men and women? And then do you also measure how much time women spend and men spend for household work, for child caring? So I'm asking whether you have regular surveys to find out any changes, to check how people's consciousness, both men and women, are developing or going backward.
Please. In the Ministry of Labor, we in fact have an annual survey on employment equality at the workplace. And it's a survey on the employed. Regarding unfair treatment and employment discrimination, these are some of the items covered by the survey. Now, regarding women, usually some women feel that they are being unfairly treated because of, for example, the raise that they get or the amount of work that they get. And for men, some men also feel that they are unfairly treated. 1.9% of the men feel that they get more work. But there are more women thinking that they are being unfairly treated. And also 29% of the women say that they need to take care of their family members. And this is higher than 28.2% among men. So there are more women reporting that they are being unfairly treated in the workplace because of their family responsibilities. So we do annual surveys, and we do follow up on these figures. Chairperson, I'm the Deputy Minister of Labor, so I would like to provide more information. The chair mentioned the so-called gender roles, and you also want to know whether there are any changes in terms of how society perceives the roles. For my ministry, this is a very important issue for us in the last 2 years. So we came up with some new measures in the last couple of years. One example was actually implemented at the start of this year. In the Gender Equality in Employment Act, there's a provision saying that if you have a child, then you can apply for unpaid maternity or paternity leave, and you can also apply for a stipend. And previously, if you want to apply for such a unpaid leave, you had to do it for at least 1 month. So 1 month is at the minimum, and the longest was 6 months. But for a lot of young parents, it wasn't very easy to use this kind of system, because sometimes there are emergency situations where maybe a new parent will need to get maybe 1 day off or 2 days off. And also for employers, if you take a whole month off, sometimes it will also be difficult for employers because they may have to find replacements. So starting this year, we changed our rules. Young parents, they can apply for unpaid leave for maybe a day or 2 days or 3 days. So as of the end of April, according to our figure, the number of such cases, the number of such applications already reached 40% of the overall number of applications. So that means that more parents are applying for such unpaid parental leave by day. And then secondly, in April, among around 18,000 cases, overall cases, men and women account for almost 50-50. So that means that thanks to the rule change, a lot of fathers are now willing to take part in childcare.
So we started to investigate this policy since last year, and we rolled out the system in January this year. That is one of the most important objectives we want to reach, which is to encourage more fathers to participate in caregiving. Actually, a lot of young fathers in Taiwan have this willingness, but at the same time, they are limited by the gender role on men. So it's difficult for them to have a longer-term unpaid parental leave because men are still the main breadwinners in the family. So if now we have the system of taking the leave by days, then more younger fathers have this willingness to participate in caregiving. Thank you.
Your replies, because I was going to ask how many men, father, are taking this unpaid day leave. Yeah, thank you for the information. I see that Taiwanese government is trying very much to change this social stereotyping of gender roles, which is good. And it was not raised, but I think gender pay gap in Taiwan is pretty much okay. And I remember that 4 years ago, we raised this gender pay gap issue, but Taiwan government responded that Taiwan is doing much better than Korea, Japan, or USA. So I myself said that you need to compare not with this badly doing countries, but rather, you know, the best doing countries, usually in Scandinavian countries, in Europe, yeah. So set the goal high, you know, rather than being satisfied when Taiwan is doing better than Japan, Korea, or USA, because all three countries are very bad in terms of gender equality. I can say that for sure, yeah. My next question regards question number 12 that we raise in the list of issues. There was an explanation about penalties imposed upon employers for the confirmed cases of gender discrimination. And we asked, what about the victims of gender discrimination? What are the measures, you know? There was no answer to this question. So I would like to ask this question again. The employers can be fined if there is gender discrimination, and then the information is on the website, you know, about the company. But what about the victims? And you said that pregnancy-related discrimination, if woman is not getting a job because she's pregnant at the time of interview, or if after being employed, if she got pregnant and then fired, then the employer get fines. Yeah, but what about the victims? What kind of measures do you have to assist the victims or to protect the victims from this kind of discrimination at the workplace?
好，
Well, thank you. First, you talk about gender pay gap. I can quickly respond to that. Because since I work at the Deputy Minister of Ministry of Labor, I asked our statistics agency and also asked our gender equality agency to make changes together. So 3 months ago in February this year, we announced the latest pay gender gap in Taiwan, and also we announced our details in the February report. Like the chairperson mentioned, I agree with that. We are comparing the OECD countries against Taiwan. Like what the chairperson mentioned, Scandinavian countries, the gender pay gap, we compare that with Taiwan. So we have all these numbers in our report because we agree with what the chairperson said. We have to compare ourselves against, better countries. We want to work better. So we have to really compare Taiwan to, better performing countries. And for your second question, on number 12, I will ask the Ministry of Labor to respond. So from the Ministry of Labor, so for Article 26 of the Gender Equality in Employment Act, it stipulates that if a job applicant or an employee is discriminated against based on gender, and the employer needs to compensate for this violation. If this employee suffers from asset or non-asset financial related damage, and then we can see that the employer needs to have a liability for compensation unless the employee proves that the employer has done everything possible legally to prevent this from happening. Otherwise, the employer needs to also have the responsibility for, asset or financial related damage. If it is non-financial related damage, well, the victim can require some financial compensation or ask for the reputation to be reinstated. Any violation in the Gender Equality in Employee Act, we can see it stipulates that within a limited period, the employer needs to make improvement. If no improvement, then the government will impose successive penalties for each violation. Well, if this violation is related to termination of job, then we will rule that this kind of termination is invalid. So this person should be able to resume her job. If this is a situation about compensation, salary deficiency, we will ask the employer to improve on that path. So it depends on where the violation is. So if there's no improvement, then we will have successive penalties for each violation. I will add some more information from our representative from the Ministry of Labor, talking about asking the employer or the actor to make improvement. Otherwise, there will be successive penalties for each violation. All this kind of information, because we have a labor inspection system, so that we will have a review to validate whether this kind of improvement has been made. And relevant penalty information is announced on the Ministry of Labor website, so the general public can see whether the company really follow the regulations, really follow the Gender Equality in Employment Act.
We are fortunate to have a deputy minister from the labor. Yeah. Then, for example, if women who were dismissed because of pregnancy, then she will be instated. She will get back to the work without going through any separate labor trial attempt? Or how does it work? The recovery for the victims. Does she have to file a lawsuit to the labor court, or is it automatic reinstatement to remedy the situation? Or if sexual harassment cases, then the employer or whoever committed sexual harassment is fined, or the employer together with the employer. But how would be protected? How would the victim protected from sexual harassment or compensated? Does she has to go through individual case raised to the administrative court, labor court, whatever? I just want to know.
好，谢谢主席。
Thank you. Thank you for the questions. I'll ask our representatives from the Ministry of Labor, and then I'll add more information later. From the Ministry of Labor, because the Gender Equality in Employment Act, and this stipulates that the employees do not need to file a lawsuit in the court to protect their rights. For employee violation of the act, the employer only needs to file a complaint for the local labor bureau, and the local labor bureau will conduct investigations and the necessary administrative procedures. And if this is confirmed, there will be a penalty to the employee. So the employee doesn't need to go to the court by themselves. So allow me to add more information. So in our Gender Equality in Employment Act, it stipulates that the employers cannot terminate women or have unbeneficial treatment for pregnant women, for example, the termination of jobs. So that is actually stipulated in the Gender Equality in Employment Act. So we can see that black and white in the act. For a pregnant employee, if the employer terminates her job, that is a violation of the law. So she only needs to file a complaint, and our competent authority will intervene and will investigate. But that is about the Gender Equality in Employment Act. And some employers, they know that there is this provision in this act about not able to terminate a pregnant employee. But still, some employers think that pregnant women are less productive, are less, performing well. So they still intend to terminate them. So sometimes the employers will use Article 11 and Item 5 of Labor Standard Act to terminate a woman employee. We see in practice some employees, because in this Item 5 of Article 11 of Labor Standard Act says that if the employer thinks that the employee is unfit for his or her role, then the employer can terminate this employee. So in practice, there are some employers using this particular provision in Labor Standard Act, saying that they are unfit for their job. If that's the case, then I have to say, indeed, some employees suffer from this kind of treatment, and then they will, like what the chairperson said, they have to go to the local government for, labor dispute approach. However, when a case like this happens, the local labor bureau will take it very seriously, because pregnancy is a very obvious fact. Thank you.
It's almost 10 o'clock, so as announced, we will have a 10 minutes break. and then come back to this question. Although we are having about now an hour of discussion regarding gender equality, but the issue is important because it concerns half of the Taiwanese population, yeah? As well as affects the equality of men also in different aspects. Yeah. So after 10 minutes break, we will come back and then we'll continue the discussion. Thank you. I realized that in the previous session, many people didn't have this interpretation equipment, so everyone was looking at the screen for interpretation. If you are not clear about the meaning of our questions, you can ask us, for clarification, of course. And I hope that you will also have this interpretation so that you can have the benefit of equivalent interpretation at the same time. Okay. So now we go back to the question of Article 3, equality between men and women in all fields of economic, social, and cultural rights. And then I just want to pose one additional question regarding gender equality, which is, since you mentioned that it is a stereotype that women suffer gender discrimination, which is common to all other countries around the world, even in the Scandinavian countries, where the gender equality index is rather high. Iceland or Norway or Finland. So my question is, what do you do? What is the government of Taiwan doing to have work and family balance for both men and women? Because it should be not only for women, but also for men. And then I was happy to hear from the Deputy Minister that now equivalent percentage of men are also taking unpaid daily parental leave, which is a welcome phenomenon. So is there any legislation that provides relaxed way of balancing so-called work and family for both men and women in terms of, for example, workers can go to work later than the normal working day, or they can take extra leave for family care, or any measures that you can come up with. So in terms of legislation, in terms of policy, what kind of other measures you have? Please.
Thank you, Chair. I'll first ask my colleague from the Ministry of Labor to respond. So in our legislation, we do have family leave. And also Article 19, there's a provision about reduction in working hours. Last year, regarding family care leave and also sick leave, we made some revisions. So the idea is to allow people to better balance their work and family. Okay, so this is from the Ministry of Labor. In the Gender Equality in Employment Act, Article 19 says that if an employee has children under the age of 3, and if the employer hires more than 30 people, then they can ask for a reduction of 1 hour every day, and also ask for an adjustment in working hours. And even for employers hiring fewer than 30 people, employees can also try to reach an agreement with the employer to reduce working hours. And Article 20 also has provisions regarding family care leave. Now, we've been looking at our provisions, and in 2024, we had a pilot program. And during this pilot program, we found that if you offer people more flexible ways to take leave, it can actually help new parents. And they do have such demand. They have demand for more flexible leave. And this will also increase male participation in family matters. So this year, we also have provisions for family care leave. Now, an employee can take leave, and they can also take leave by the hour. Originally, you can only take leave by day, but if you are a parent, you know that sometimes certain things will come up. Any time of the day, perhaps the teacher will tell you that your child is ill and so on. So for employees, sometimes they only need a couple of hours. So that's why we now have a more flexible approach. So now the new rule is that the family care leave can be taken by the hour. And we found that this flexibility actually encourages father to take part in childcare. So again, we've been looking at our provisions. I think that in Korea, there are also a lot of measures that we can learn from, particularly in the reduction of working hours. And in Taiwan, NGOs, civic groups also gave us some suggestions. And legislators also gave us certain information. So we are now also discussing how we can revise our policies in order to offer more flexibility. And this way we can really help new parents. And I mentioned Korea. So in Korea, they also have certain accompanying measures for the workplace. And we are also looking at the Korean measures and see how we can adapt them to suit the Taiwanese context. Chair, I would like to add a couple of things. First of all, like my colleague said, Article 19 of the Gender Equality in Employment Act says that if an employee has children under the age of 3, they can apply for a reduction of 1 hour in terms of working hour, or they can ask for flexible working hours. And my colleague also mentioned that in the last 6 months or so, we've been collecting information from NGOs and also legislators. In addition, we are also looking at the measures implemented by Japan and Korea. In Japan and Korea, they both have measures where if employees reduce their working hours, the government would actually provide certain subsidies to the employees and employers. So for example, for employers to find replacement and so on. And we hope to be able to announce our new policy in the near future. Article 19 of the Gender Equality in Employment Act has been going on for a long time, but the provision says that the reduction of 1 hour means that you don't get paid for that hour. That's why certain employees are reluctant to apply for such a reduction in hour. That's why we've been looking at the measures in Japan and Korea to offer compensation as well. And then previously we talked about the unpaid parental leave. And I mentioned that our laws say that the unpaid parental leave could be as long as 6 months. But returning to your question regarding how we can address gender stereotypes, we want to encourage men to take part in childcare as well. So we hope to be able to revise our law, especially in our Employment Insurance Act. And recently, the Premier also announced that we intend to revise the Employment Insurance Act. So if both parents each take 6 months of unpaid parental leave, we want them to be able to extend the time. It could be 6 months plus 6 months, and then an additional month. It could be more than that. Our goal is to encourage fathers to take part in childcare. We don't want all the responsibility to fall on the shoulders of mothers.
Thank you. As long as this leave affects income of male workers or female workers or promotion at the workplace, it would not work. So I think there should be measures of paid leave. You know, if it's unpaid, that would affect the family income, which would block the workers, either male and female, you know, take the leave. So we need to assess what would be the impact of any measures, you know, government measures. Regarding parental leave or maternity, paternity leave, I will be back when we deal with the issue on family tomorrow. So there can be more discussion on that. But for now, I'll stop here. And just one more additional information. In Korea, although we are not doing such a good job, and gender discrimination at the workplace is a big issue. In addition to the gender pay gap, you know, our Ministry of Gender Equality and Family is doing one thing is they identify woman-friendly companies and then acknowledge that this company is really taking policies or measures regarding their female employees, which contributes to the high profile in the society so that people recognize that, oh, that company is really working for female employees and then gives a good impression, you know, rather than financial benefits directly, but it's another way of indirect way of increasing gender equality. So you might also consider that as an example. I don't know, yeah. But they have events, celebration, recognizing, you know, all the companies as woman-friendly companies. Yeah. And Rosalind, you want to add something?
Yes, thank you for this very helpful discussion and encouraging one too, to see the measures that are being taken here in relation to equality between men and women. There's just one issue that I wanted to sort of flag. It's not only related to the workplace, but there is a lot of evidence that one of the factors, as well as caring responsibilities, that undermine equality for women, particularly in the workplace, and that's the extent of domestic violence, the extent of you know, intimate partner violence that women face within the family. And I see from information available that according to the Garden of Hope Foundation, every year in Taiwan, over 150,000 people become victims of intimate partner violence or domestic abuse. And of course, it can in some instances, although it's very much the minority, men can be victims as well, but the overwhelming majority everywhere, it's women. And I know it's often a taboo, it's a taboo topic. People don't want to talk about it. In many places, you know, and including in New Zealand in the past, it wasn't, you know, it was something that went on behind closed doors. But it often means that the victim has to take time off work to recover if there's a serious physical abuse, or that the psychological and emotional abuse makes them less productive. And so I just wondered, and very recently in New Zealand, a law has been introduced that requires employers to provide a certain amount of paid sick leave where someone has suffered domestic violence. So I just wondered whether this, I mean, it won't just be limited, obviously, to the Department of Labour, to the Ministry of Labour, but whether this is also a factor as Taiwan looks at comprehensively promoting equality between men and women, whether that's part of the overall program to not just get men undertaking caring responsibilities, but also bringing up our boys and our young men and men generally not to use violence at all, but certainly not in terms of family relationships.
The issue of safety and personal integrity or liberty is a big issue for women. You know, the rape, sexual assault, domestic violence, sexual harassment happens, and then nowadays it is a really serious problem. Stalking, you know, we have laws everywhere, but still is not enough to prevent those issues. But I hope that the other committee on civil and political rights will raise that issue also there. So that's why I was not raising that issue here. Yeah. So division of labor between the two committees, but that issue is certainly. And then your suggestion to look into whether there is more that government can do in terms of domestic violence, how the employer can give paid sick leave if domestic violence happens. You know, that's one additional tip that you might consider. Okay, so now I think this concludes our discussion on Article 3. And then this morning, since we are devoting our time regarding Articles 1 to 5, if any additional questions there is under Article 1 to 3, then I would give the chance to other colleagues. So, yep.
Thank you. Yeah, I would like to raise an issue that was also addressed yesterday during the general debate we had. The issue of indigenous languages and linguistic discrimination. We have heard that there is still continuing predominance of Mandarin in public life, in education, judicial proceedings, public administration, public services. And we are interested in whether or not the government is planning to actually recognize or even to take concrete measures to promote indigenous Taiwanese languages in public institutions, so judicial proceedings, perhaps also public administration or services, in order also to facilitate access of indigenous languages or of groups speaking indigenous languages to these public institutions.
Let me see whether any other colleagues will raise issues. So, because we should divide the time remaining, So I'll ask each colleague to raise the question all at once, and then you can reply to either. Yeah. I will first give the floor to Ms. Rosalind Nunan, and then after you, and then, okay, so.
Just before I ask the question I'm going to ask, can I also just add, supplement what my colleague has just asked, which is in relation to what we understand from the submissions received to the Taiwanese language, which over 70% speak, so it's separate from the indigenous languages. The question is that, you know, that is one of the questions that's been brought to us as to why that's not used equally, at least with Mandarin, which was imposed from outside. So that's just to clarify, or to add, sorry, supplement. The question that I just wanted to go back to, you know, because one of the things that we've been looking at, that we looked at yesterday in depth, so no need to do it in depth here, is in relation to the importance of the National Human Rights Commission, the value of the National Human Rights Commission, and what it needs to be more effective in promoting and protecting human rights in Taiwan. And the question I want is really directed to the government. We received information from the National Human Rights Commission about the impact that some of its reports, its recommendations from complaints, etc., the impact they've had, the way the government has responded. But again, in a number of cases, for example, one which I think is very important in relation to an independent opinion under the Second National Report on the Convention on the Rights of the Child, the National Human Rights Commission raised recommendations about the provision in the Civil Code that allows parents to discipline their children. And in terms of the specific actions adopted by the Executive Yuan, the report says a draft amendment to the Article 1085 of the Civil Code was prepared in 2023. It's now 2026. So I just wondered, you know, that's an example of, so when there's some initial action, my question, well, two parts to my question. The first part is, when a government agency receives a report from the National Human Rights Commission on a human rights matter, what action does it take? How does it deal with that report? And the second question is, if the National Human Rights Commission, how does the National Human Rights Commission monitor the report, and what does it do to follow up when there appears to be an initial response but actually no action in practice? And I could have used a number of examples from the Commission's own report to see that there was initial reaction and there was a draft of this or an amendment being developed, but actually nothing more has happened. So how does the government respond if it receives a report, and what does the Commission do to follow up on very significant recommendations, such as the one I just used as an example relating to the discipline of children?
Thank you for your question regarding National Human Rights Commission and then government's action. And then Mr. David Richard Boyd.
Thank you very much, Madam Chair. This is my first time as a member of the International Review Committee, and I'm very grateful for the opportunity to be here and to be learning so much about Taiwan, and appreciate all the information you're providing to us. So one of the first things I did in preparing for this meeting was to read the previous concluding observations of the committee from 2013, 2017, and 2022. And in each of those concluding observations and recommendations, there is an issue raised that is really important to Indigenous people's rights, and in particular the Tao people from Orchid Island or Lanyu. And that has to do with the storage of approximately 100,000 barrels of nuclear waste in their community without their consent. And so the recommendation of this International Review Committee dating back to 2013 has been to provide compensation to the indigenous peoples and to remove as expeditiously as possible the nuclear waste from their community. I also learned from a media report that there was a 2024 report published by the Control UN, which investigated the status of these 100,000 barrels of nuclear waste and found that some of these barrels were deteriorating and that this waste is not really being safely stored. So I have two questions which I would love to hear your response to. First is, in response to that report from the Control UN, what actions have been taken to ensure that the nuclear waste is in fact being safely stored? And secondly, given the failure to remove that waste dating back more than 15 years, despite the recommendations of this committee, what is the plan for actually removing this waste from Orchid Island? And what is the timeline for removing this waste from Orchid Island? Thank you very much.
Orchid Island is a beautiful name. We hope that to keep Orchid as Orchid now without...
it's more than a
nuclear
beautiful
waste.
name. I've looked at photographs and pictures online, and it's also a beautiful, beautiful place. So,
Okay.
nope. I understand this is a very difficult issue. In fact, it's a challenge that all nations that have used nuclear energy face, which is how do you deal with the nuclear waste? Because really nobody wants it in their community. So it is a challenging issue, but it's important that action be taken to address it.
Okay, thank you for your question. Next, Mr. Milun Kotari.
Yeah, thanks, Chair. It's good to have these extra minutes to come back to the question on the rights of the indigenous. The statistics that we have indicate that more than half of Taiwan's indigenous population lives in urban areas. And there have been, and you know, Taiwan has, it's very good to see, developed policies specifically addressing urban indigenous populations. But in terms of the information available to us, the question of subsidies, relocation, consultation on the housing conditions remains unsatisfactory. So I wanted to know what are the plans right now in terms of meeting the rights of urban indigenous people. There are two settlements in particular. We may be bringing up this question when we look at the housing article, Article 11. But there's a Lavake settlement, Ravak in Kaohsiung, Zhongsheng public housing. And there are a lot of questions around ensuring long-term housing stability, security of tenure, and so on. So I just wanted to know what are the current plans of the government in ensuring that the indigenous who are in urban areas have secure conditions. Thank you.
Thank you. So it is particularly on the housing conditions of the indigenous people living in urban area, yeah, not just housing situation in general, which will be dealt with tomorrow, yeah?
Yeah, but it's also about half of the population is here, so it's not only housing, it's also the general conditions of indigenous people in urban areas.
All right, okay, so you have 4 additional questions from us, and if you can calculate the time allocation, we have approximately less than 40 minutes, so maybe not more than 10 minutes for each question. Yeah, if less, that would be okay. Thank you.
好，谢谢主席。
Thank you. Thank you for the question. So indigenous people in terms of linguistic discrimination, I will ask CIP to answer. Also, there's a question about the rights of indigenous people in urban areas. I will also ask CIP to answer. In terms of public service, For example, the Taiwanese language or in public service rendering. For non-Mandarin services, I will ask the Ministry of Culture to answer. For NHRC report, how does the government respond and take actions? I will ask the Human Rights Agency of the Executive Yuan. And for the Civil Code, the punishment from the parents to the children, I ask Ministry of the Judicial Yuan. I'll ask the law enforcement to answer this. And for Lan Yu, I ask MOEA. So CIP first. Well, thank you for the question. For the linguistic discrimination of indigenous people, in 2017, we passed the Language Development Act for indigenous people, and indigenous languages have been defined as part of the national languages. So this is a protection over indigenous peoples. So in terms of the promotion of the use of indigenous people, so we can rely on this origin of law. And CIP have a lot of efforts to encourage the use of indigenous languages. So in townships, in offices, we have activities to reactivate the use of indigenous languages. In 2019, in addition to the Language Development Act, so we can see in 2019, the National Language Development Act stipulates that for Taiwanese language, Hakka language, indigenous language, and the sign language of Taiwan receive the same status and protection. So this act attributes to the protection of different languages in terms of cultural equality. Thank you. I would like to add that for CIP, for indigenous people in urban areas, we have an urban indigenous people development plan. So every 4 years, we revise this plan. So far, it's been 20 years. We have done this 5 times. So for urban indigenous people, in terms of their employment, their health, their living conditions, their housing rights, in our plan, we continue to assist urban indigenous peoples. And for connection with their original community while they live in urban areas. So we focus on their language and cultural preservation while living in the cities. And in our plan, we have specific plans and subsidies. In terms of housing in urban areas, we have subsidies, and the Ministry of the Interior and the local governments have their own respective subsidies. And for social housing, indigenous people have priority to have the right to live in social housings. So in different aspects, we have special care, special programs for indigenous people.
This is from the Ministry of Culture. So regarding a language-friendly environment, in the National Language Development Act, it already stipulates that all the languages are equal and should not be discriminated against. And under this law, we understand that we also need the cooperation of different ministries and agencies. So, for example, the Ministry of Education and also the Ministry of the Interior and so on. So all of us have to work together to promote the equal status of different languages. Then if you have taken the metro in Taiwan, then I think you will notice that we have different languages, including Mandarin, Hakka, Taiwanese, English, and so on. And in the Ministry of Culture, we also provide subsidies for example, museums to provide guided tours in Taiwanese and Hakka languages as well. And we also encourage events by the private sector in different languages, and we also provide subsidies to local governments to create a more friendly environment for different languages. But of course, I think people are still more used to using Mandarin in the public arena, but we are still working very hard. And then I would like to ask the Department of Human Rights to say a few words. Hi, ladies and gentlemen. So regarding the NHRC report, at the Department of Human Rights in the Executive Yuan, if we receive any NHRC reports, we'll first review the reports to see what agencies are involved, and we'll ask agencies to provide responses. For example, what are some of the laws that need to be changed, or they can respond to the issues identified by the NHRC. A lot of reports mention issues that will require coordination among different agencies. So when we in the department receive the reports, we also act as a coordinator. So basically, we have to look at the responses by different agencies to the NHRC report, and then we'll relay these responses to the NHRC. And this is not just a one-off process. We and the NHRC are working very closely together. And then regarding the responses received, if the NHRC feel that the responses are not adequate, then the government agencies involved have to provide further information or provide revisions. The Ministry of Economic Affairs, please. This is from the Ministry of Economic Affairs. I would like to respond to the nuclear waste issue on Orchid Island. In 2025, so last year, our ministry set up a task force regarding highly radioactive waste disposal. And so the task force is about working on the transfer of the nuclear waste. Now, we've been working on some preparation work in legislation, and we've also been communicating with experts and NGOs. We've selected 2 locations for low radioactive waste. One is in Taidong, the other one is in Kinmen, the outlying island. But of course, we also need to consult with the local communities and local indigenous tribes. And we also need to secure their approval before we can move the nuclear waste to these 2 other areas. So before we can move the nuclear waste, we have to continue to work with the Nuclear Safety Commission and the Council of Indigenous Peoples to try to find out a more viable timetable. And then the Ministry of Justice, please. In 2024, the Executive Yuan already deleted the parents' power to discipline children in Article 1085 in the Civil Code. So the Executive Yuan already deleted it, but this had to be approved. This has to be approved by the Legislative Yuan. which has not yet approved this change.
For your replies. Regarding language issue, I believe that this event organized by the government is not translated into Taiwanese or Hakka language, yeah? But translation is only in Mandarin. Right, so that shows that it's not really equally treated in real sense, in the real situation. So I will try to ride the subway and to see the various interpretation in other languages, yes. Any additional questions? Yes.
Yeah, thank you. Excuse me. Thank you for your answer on the question of the nuclear waste. However, my understanding is that the two locations you mentioned of Kinmen County and Taitang County were identified decades ago. So I'm wondering what different actions are being taken if those communities are not ready to welcome the relocation of this waste to their communities. And secondly, my other question was what action has been taken since the report of the Control UN in 2024, which found that this waste is not currently being safely stored.
So we will wait for the replies, but may I point out that we are still waiting for the response from the National Human Rights Commission regarding what kind of monitoring you are doing about government action after National Human Rights Commission issue recommendations. Okay, so first regarding the nuclear waste issue, who is going to answer that?
The Ministry of Economic Affairs, please.
是那个经济部这边回。
Alright, so the two sites indeed were selected back in 2012. So that was quite some time ago. But site selection involves, for example, expertise in nuclear waste handling, and also we need a referendum that receives that can secure the approval of local communities. So this is a lengthy process. But currently, we are still focusing on these two sites to see whether we can find a solution. Orchid Island, the nuclear waste storage sites. After we set up a task force, we in fact conducted further management measures to make sure that the radioactive level will not threaten the local people. And Taiwan Power Company currently also stores all the low radioactive waste in eligible and qualified storage and transportation containers. So when the relocation project is finalized, then we can move the nuclear waste out of Orchid Island.
Thank you. Yeah. Any response from the National Human Rights Commission?
谢谢委员刚才提。
Thank you for your question regarding how the NHRC can follow up on government action after we issued recommendations. So we have several measures. Just like what the Department of Human Rights said, after we issue a report, we'll continue to follow up on responses from relevant agencies. And this is not a one-off action. After we receive the responses, we'll also conduct analysis. And if there are questions, we'll talk to stakeholders, including NGOs, and then we'll reply to the government. We'll also publicize government responses on a website so that the public can see how the government responds to our recommendations. In addition, when we attend government meetings, we'll continue to follow up on the various issues. And then, for example, in our independent opinions, we also include in our independent opinions the actions of the government and how they can further improve. Another thing is that regarding major human rights issues, we invite government agencies to our administration, to our commission, or sometimes we also go to government agencies for further consultation. So, for example, regarding migrant worker rights and also disabled prison inmates, all these issues. Regarding all these issues, we continue to talk to government agencies, and we receive friendly responses from the government. Recently, we also give our recommendations to the Legislative Yuan. So, for example, when the legislative branch was revising the People with Disabilities Rights Protection Act, we gave them our recommendations and views as well. And in seminars or conferences, we also publicly discuss various issues with the participants.
Yeah, thank you. Mr. Jochen van Berenstoff for additional questions.
Thank you, Madam Chair. I would like to come back to the question of linguistic diversity, and thank you very much for your answers on that topic and on the situation of both indigenous languages and Taiwanese Hokkien, so Taiwanese language. And apologies for my ignorance regarding the concrete situation. It's very complicated to understand the linguistic situation in Taiwan from outside. If I understood you correctly, there are like two issues really. One is that the government has, through the legislation, promoted the use of indigenous languages and also Taiwanese Hokkien, if I understood you correctly, through this legislation. And so because of the fear that these languages might die because they are not being used anymore by large segments of the population. And then there's the other issue that has also been raised by submissions in this review procedure, that there might be a problem of access of with regard to Mandarin, or because of a lack of knowledge of Mandarin, so that indigenous people or also people only speaking Taiwanese Hokkien have problems in public administration, in judicial proceedings, because they can only communicate, they're supposed to communicate in Mandarin, but they have not a sufficient knowledge of Mandarin. So, and my question would be, how big is this problem? How large is the segment of the Taiwanese population that does not speak Mandarin and that would actually face these difficulties in public administration, before court, in these situations? How big is the problem? How large is the segment that does not speak Mandarin and can, for this reason, not access these institutions? Thank you.
So, Ministry of Culture, please. So, from Ministry of Culture, I talk about, Taiwanese, Hakkanese, and then indigenous languages, Mandarin. And we know there are many indigenous languages, and they have a specific law for the indigenous people for accessibility in public services in terms of our experience. Actually, lots of people can understand and communicate in Taiwanese. But because of past policies, people think that, for example, in the court, people should use Mandarin. So Taiwanese-speaking people will be refused to use Taiwanese. However, it would be easy to find Taiwanese Mandarin interpreters. For example, I think I can do that as well. So I think for general communication purposes, there should be no problem between Taiwanese and Mandarin interpretation.
Are we all satisfied with the replies given by the Taiwanese government representatives? Yep. Thank you very much for this very constructive session. I think we had very frank, straight questions and replies received. We still have 15 minutes, but we can finish early. Yeah? Thank you very much. And then we expect that we'll see you again at 2 o'clock in the afternoon. Yeah? And then have a good break, and then let's meet again at 2. Thank you very much. 谢谢. This morning meeting is adjourned. Yeah, but after this, at 11:30, we are meeting with NGOs. 11:30. Yeah. 30. Yeah. 11:30. So we can have break until 11:30. Thank you.
本场次会议被。
National review meetings of the fourth national report on the ICESCR Session 2 now begins. The chair will decide on the order of speaking. When you speak, please make sure that you do not speak too fast for the benefit of interpreters. Before you speak, please identify yourselves and also turn off your microphones after speaking. Thank you.
Thank you, and welcome to this session between the Review Committee on ICESCR and the NGOs in Taiwan. I'll explain what we want to do. Instead of listening to you one after another, we will ask questions regarding three big issues that we dealt with during the morning session with the government representatives. So it is, first of all, on indigenous people's issues, and that there are small questions, issues that we raised. Second one is on business and human rights issue, and then third one is on gender equality. So before we start to ask you questions, I would like to know how many of you are working on indigenous people's issues? Okay, so 5 organizations or 5 people from less than 5 organizations. 6. Okay, 6 people. How many of you can answer the question regarding business and human rights? 1, 2, 3, 4, 5, 6, 7, okay. And how many of you can answer the questions on gender equality? 1, 2, 4, 5. Okay, so among our 6 members on the panel, the first issue on indigenous peoples, the questions will be asked by Mr. Jochen van Wernstoff, and then by you? No? Yeah, and then, yes, 3, yeah? So 3 of them will ask questions regarding indigenous peoples, and then business and human rights, of course, Mr. Olivier de Schutter, and gender equality, myself, yeah. So we will go in that order. And we would like to find out from you what you think of the government's response or replies. And if you find some points that you don't agree, their explanation given was not correct in terms of facts or situations, or interpretation was different, the nuances in the situation, especially regarding the indigenous people's situation. So I will ask Mr. Jochen von Bernstoff to ask you exact questions regarding indigenous peoples. So after him, yes, David, and then Milun.
Thank you. Yeah, we raised in the morning the issue of the recognition of the Pingpu peoples, and the government replied that they are aware of the fact that they need new regulations or a new act. I'm not sure which legal status exactly this new legislation has. They are working on it, and they want to have a more substantive regulation on giving Pingpu peoples concrete rights, equal rights compared to other indigenous peoples, even though they are excluded from the general, as you know, legislation on all other indigenous peoples. So they say they are working on it, and I would be interested in whether or not you are involved in this process, or indigenous organizations, representatives are involved, and what you know about this process and what you expect to come out of this legislative exercise. Thank you.
Maybe it's better to ask additional questions from your point of view so that you can sort out who answers which questions, yeah?
Thank you, Madam Chair. So one of the issues we raised with the government this morning was the long-standing issue of the disposal of nuclear waste on Langyu Orchid Island in the territory of the Tao people. And obviously this is a situation that's been going back many years, and the government said, well, we're working on it. We've still identified these 2 sites, and we're continuing to consult with the people there in an attempt to move forward. So I'd be very interested in hearing your perspectives on whether the government is moving expeditiously, whether their plan has actual potential of being successful in relocating the hazardous nuclear waste away from Langyu to a more safe and acceptable waste disposal site. Thank you.
Yes, hello everyone. One of the questions we raised was about the current status of the government's post-disaster relocation policy. The example we used was what happened after the Morakot typhoon, and the response was that yes, we are working on that, but we pointed out that there's still many that the communities were affected were moved very far away, and the government said yes, they were, because it's not possible to have them move closer, because we raised the issue of the loss of livelihood, of sacred rights, and so on. And so it would be good to know from you what the current situation is about those indigenous who were affected by Typhoon Morakot, but generally on the issue of post-disaster reconstruction, and whether it's whatever framework the government has, is it a human rights-based framework, and also there is a very good free, prior, informed consent legislation, but in practical effect, is that being implemented? And the second issue we raised was the issue of that half of the indigenous population in Taiwan is in urban areas, and what is their condition, and what is the government doing to improve the living conditions and so on. And we referred in particular to the Lavake settlement and the Shonshung public housing. So it would be very good to know from you what the current status of these 2 situations. Thank you.
Thank you. So among 5 of you who are working on indigenous issues, I think you need to have division of labor. So don't repeat the same answer if the answer is given by another organization. Yeah. So who would like to go first? Yes, please go ahead.
Hi. I come from an NGO, and I remember yesterday it was said that the identification of the Pingpu peoples is actually in violation of the self-identification and the rights protection. And I come from the Taiwan Indigenous Youth Public Participation Association, and we agree with what the committee members said yesterday. Before the legislation, the CIP in fact convened several public hearing sessions to listen to the views of the Pingpu peoples. Most Pingpu peoples believe that they should be included by the original indigenous peoples' law. But from what we saw is basically an independent law specifically for the Pingpu people. So they are not included in the Indigenous Peoples Identity Act. And also, I think the identification standards are also problematic in that you have to come up with certain historical documents and so on. But of course, in Taiwan, we have seen a lot of regime changes. So certain Pingpu peoples do not have documents to prove their identities. But does that mean that they are not Pingpu peoples? So that's a problem. And also, some Pingpu peoples don't want to be called the Pingpu people. And I think that's a very important point. And we also have to think about decolonization. Mountain indigenous peoples, plains indigenous peoples, Pingpu indigenous peoples, these three categories were actually given by colonizers. And then the Republic of China government basically continued this colonizers' framework. So for example, my grandparents, they were registered as mountain indigenous peoples, and some people would maybe wondering whether I actually came from the mountains. But in fact, I was born and bred in cities. It's just that my ancestors were registered as mountain indigenous people. So somehow, for generations, that we are seen as mountain indigenous peoples. But this doesn't reflect who I am and the real situation. So it's not just that the Pingpu indigenous peoples are being set aside. I think the whole categorization has to be reviewed. It has to be decolonized.
You want to?
I also come from the same NGO. So just in continuation with the Pingpu people's topic, so now with the dedicated law for the Pingpu peoples, I think we have to think about for example, some basic rights like voting. Now, in Taiwan, in the legislature, there are seats for mountain indigenous peoples and plains indigenous peoples. But what about the Pingpu peoples? And then regarding Orchid Island nuclear waste, so a question was asked whether there's a safer location. But I want to mention another issue. In March, the president of Taiwan said that Taiwan will reopen nuclear power wastes. And previously, several locations in indigenous territories were designated nuclear waste storage areas. But the tribal communities were not consulted before. So we cannot be sure whether the FPIC principle was upheld. And I think a lot of people are quite anxious because many tribes are worried that they might end up like Orchid Island. And I also want to respond to the issue of forced relocation. You asked whether we have a better response measure. Now, in September last year, there was a very big typhoon in eastern Taiwan. And again, quite a lot of indigenous people had to leave their homes again. So, and also during the process, we also noticed the issue of language. Mandarin used in public life can be difficult for some indigenous peoples. And but because of the language barrier, some indigenous peoples were seen as not cooperative. But the thing is, some people didn't really understand Mandarin, so they had no idea what the government was telling them. And also, there were cases where farming crops were destroyed. But in a situation where there's emergency or in a situation where you need emergency response, I think the government also has to pay attention to the language issue. Now, it's been 16 years since Typhoon Morakot, and currently we still face issues regarding land ownership. So some people were relocated, but what about the land? So that the problem is still there. And then I also want to respond to the issue of the overall planning. This year, we were told just a month in advance, we were told that indigenous tribes had to stop their knowledge center and language promotion center. So we were only given a 1 month notice, and that's a very unfriendly action to do.
Thank you very much for the information you provided. Okay, yes, please go ahead.
I'm from New Vitality Independent Living. I'm also an indigenous person with disabilities. I want to respond to what I heard in the morning about urban indigenous people and their situation, because I am in because I have these intersectional difficulties. In the morning, I heard the government responding that government has special assistance for housing for indigenous people. However, as a person, an indigenous person with disabilities, actually, I am not able to be receiving the help that I need, because for people with disabilities, in terms of social housing has special, like quota for indigenous people. However, for indigenous people with disabilities, there is no, for example, barrier-free housing specifically for indigenous people with disabilities. So that means we have to face this issue that we have to compete with, the other population. So there's no specific arrangement for indigenous people with disabilities. So I just wanted to respond to what I heard from the government this morning. Thank you.
Helpful if you can provide, for example, how many indigenous people with disabilities need social housing, barrier-free housing, and then what number actually of housing is supplied. Yeah, that would be helpful for us to give exact concrete recommendation if you have the figure. If not, we'll just raise the issue in general.
All forms of social assistance, not only related to housing, the general conditions of the indigenous in the urban areas.
But other issues like social security issues can be raised in the afternoon also. So you are addressing the housing issue for urban indigenous people, especially with disabilities at this moment. Yeah? And then we will also look forward to the afternoon session if we have any other issues regarding other articles of the covenant. Okay, yes. Any other indigenous people's issues from other organizations? It's covered. Okay, yes, you have the floor. A lady first and then.
I'm the CEO of Environmental Rights Foundation. We are helping tribal communities for development in terms of FPIC issues. Later, I'll talk about issues related to FPIC, but I first want to respond to the procedures that mentioned by the reviewers. For Typhoon Morak in 2009, because the tribes have been relocated for more than 10 years. So there are now new issues coming up. For example, for their current residency, they want to get the right to land because this land belongs to the government. And for their old houses, it has been swept out by rivers, so they can never go back. So when they are striving for their rights to land, they want to use the old land in exchange for new land because the old land has become part of the river. And the government doesn't allow with this kind of exchange. So now they only have rights to their current housing without the rights to the land. So they have this heightened sense of insecurity over land. In the morning, the ICESCR asked about Kenelulan wetland development. So after helping the consultation with the tribe, actually the government, the court has ruled that it's a violation of the law. And then when we help the tribes in terms of natural resources management, because this tribe has geothermal energy, so we encourage the tribe to use renewable energy to have energy autonomy. But when the tribe signed a contract with suppliers because the tribe has their own self-determination way to develop geothermal energy. When they signed a contract with the supplier, with the manufacturer to talk about developing the power. However, CIP told the supplier, told the company that you can only follow our way to do FPIC. If this is recognized only by the tribe, then we will not approve of that. So the contract signed in March this year became ineffective, invalid. Although in the morning, the government said that they are now amending this regulation. They are, formulating new law. However, because the old one has a lot of problems, and we don't know when the new one will be ineffective. So we hope you can tell the government that before the new law has been passed, we should respect the communities. We should respect their customs so that they can have the final say for their decision. Rather than asking the tribe to follow the old law. Because this really angers us that when CIP, for example, is communicating with other government agencies or with suppliers, they say that this law is ineffective. So that really angers us. So I hope that CIP should respect the autonomy of the tribe. Thank you. I'm a lawyer from the Environmental Rights Foundation. I want to talk about the law to add more information about what our CEO said. So for the Kenelulan wetland solar energy case, so CIP proposed the amendment to the regulations on obtaining the consent. However, if the new law is not, is not promulgated, when the amendment is still ongoing, this will create a lot of restrictions on the tribal autonomy. For example, there will be two situations in the law. First, the tribe have their own regular autonomy regulations. And secondly, according to their regular autonomy regulations, the tribe has signed a contract with the supplier, with the manufacturer. And without the approval of the local government, the tribe will encounter a lot of difficulties. For example, the power of the autonomy regulation is not recognized by the local government, and there are a lot of restrictions over this decision. So I think this is an infringement on the right to autonomy for the tribe. And the CIP proposed this new draft on obtaining the consent. Actually, this is a lower level regulation. There are also other higher levels of laws. So I will encourage the government to use the Indigenous Basic Act to the basic law so that we can really protect the tribe in terms of making decisions.
Is there any additional questions you want to raise regarding indigenous peoples? Otherwise, we will close this discussion, yeah, and then go to the issue of business and human rights. So, Olivier, what questions do you have for the NGOs?
Yes, good morning again to everyone, and thank you so much for the contributions you can make to our deliberations. We know that consultation is now taking place on the second National Action Plan on Business and Human Rights. And I was hoping you could provide us with an understanding of the most contentious issues that are debated in the preparation of this National Action Plan. More specifically, what do you see as the priorities that should be in the National Action Plan, and what are the obstacles for those priorities to be taken into account? And especially if you could comment on the issue of human rights due diligence, that would be extremely helpful. So I'm not sure whom would like to respond, Madam Chair.
Okay, so I'll ask Covenant Watch, and then you. 1, 2, 3, 4, 5, 6. Okay. We have to leave 10 minutes for the discussion for gender equality. So we have approximately 13 minutes, or no, 23 minutes for this discussion, which I think would be enough for 6 people. Yes?
Yes, thank you. This is Covenant's Watch. I think one of the important limitations in the due diligence is that there is a lack of the methodology that is required to perform human rights impact assessment, both on the government side and also, but also the method has not been applied on the business. So I think that is the major obstacle. But can I also talk on the progressive realization of economic rights? I think that was raised in the morning. So progressive realization in terms of appropriate tax burden to ensure that everyone enjoys economic and social rights in relation to, but particularly to poverty, but not limited to the poverty. The tax revenue increased in the past few years, not because of changes in tax rate, but because of more tax collected because of an increase in GDP. So there is actually more provision of community social services in recent years. That is the fact. However, the government has not ensured that everyone enjoyed adequate standard of living. This can be exemplified by the very stringent criteria set out in the Public Assistance Act to become eligible for assistance. More importantly, the government has not established a baseline of adequacy of living conditions. So the government has no assessment of exactly how many people are suffering from daily hardships. On the other hand, the government faces limitations in resources when various government agencies are trying to provide services. This has a wide range of effects, such as very heavy workload for social workers in the communities, poor living conditions in prisons, inadequate rehabilitative functions of the juvenile corrective institutions, and a lot of many different examples. In short, the government does not recognize that there is a shortage of tax revenue because of its complacency in accepting inadequate conditions of marginalized populations. Thank you.
Thank you. That also relates to our afternoon discussion regarding social security. and tomorrow's discussion on adequate standard of living, yes. But we take it, your point on tax revenue mobilization, yes. Yeah.
好，谢谢委员。
Thank you. I'm a researcher from the Taiwan Association for Human Rights. So regarding the action plan, first of all, we would like to say that the Ministry of Economic Affairs is severely delaying this policy. So phase 1 of the National Action Plan already expired, but the second version hasn't been approved. So the ministry said that they've been consulting the public, but I have to say that this is insufficient. We in civil society participated in the public hearings organized by the Ministry of Economic Affairs, and we provided a lot of concrete recommendations, including mandatory human rights due diligence, but that was not included in the government's national action plan. The Ministry of Economic Affairs is only willing to provide so-called due diligence guidance, but the guidance has not been passed either. Last year, an important company in Taiwan called Giant was issued a WRO by the U.S. And this year, the Taiwan-U.S. trade agreement was passed. And that was the moment when the Taiwanese government realized that human rights and due diligence in supply chains are very important. So the Ministry of Labor is actually more proactive than the Ministry of Economic Affairs, especially when it comes to forced labor guidance. The Ministry of Economic Affairs believe that small and medium-sized enterprises, which comprise 95% of all Taiwanese companies, don't have the capacity to do due diligence. But we think that this is not a good reason. Supply chains around the world, including those in the US and the European Union, already have regulations regarding due diligence and forced labor. So we believe that the Ministry of Economic Affairs should use legislation to make Taiwanese companies realize that they need to pay attention to human rights. And due diligence can actually help raise the competitiveness of SMEs in Taiwan. And the government should lead the way so that companies also pay attention to human rights issues. And the review committee members mentioned a very key topic. And I think one important topic in business and human rights is the discrimination of migrant workers in Taiwan. In Taiwan, we already have 870,000 migrant workers. And if you include those who have gone missing, there are about 1 million of migrant workers. And in Taiwan, there's systematic discrimination, exploitation of migrant workers, especially foreign fishers. But the Ministry of Economic Affairs National Action Plan doesn't include foreign fishers because the ministry think that there's already a fishing human rights action plan. But we don't think that the two action plans should be mutually exclusive. The National Action Plan on Business and Human Rights should encompass all sectors. It's just it's unfortunate that the second version of the national plan hasn't been passed. So we hope that the review committee can make recommendation to the government that they should require mandatory human rights due diligence. Thank you.
Yes, thanks.
好，委员好哈。那个
Ladies and gentlemen, good afternoon. I'm an observer from the Tax and Legal Reform League. And in Taiwan, I would say that there's some kind of tax violence. So often after tax filing, companies will actually receive phone calls from the tax bureau asking for more tax payments. And I think that's also a reason why wages are low in Taiwan, because companies have to set aside certain money to pay the National Tax Bureau. So the reason is that there's so-called virtual tax bills. And if companies seek remedy, that also takes up a lot of resources. So all companies are very afraid of the National Tax Bureau. And the Bureau basically does whatever it wants. And in Taiwan, we see that if people sue tax authorities, and in Germany, there are 40% chances for people to win. In the Czech Republic, 50%, Denmark, 60%, India, 50%. In Taiwan, only 0.3%. And yesterday, we also mentioned the Taijimen case. Now, it's not a business, it's a cultural group, it's a religious group. And the case has been going on for 30 years, and this is a kind of tax violence. It's a violation of human rights. And we also hope that the review committee can look into this issue so that we can protect business and also human rights.
Any other people on business and human rights? Okay, you first, and then.
Hi, I come from Amnesty International Taiwan. So regarding business and human rights, I want to also mention a few things. The manufacturing sector is required to disclose a series of topics, but agricultural sector and also distant water fishing are not included in the obligation to disclose. And also internet platforms, digital platforms, they also have severe problems of, for example, discrimination, hate speech, and so on. All these should be put into due diligence. But the draft plan doesn't include this. So we don't have a mandatory human rights due diligence obligation. If this is not mandatory, and that means that the government only provides soft guidance. And that's a problem. And that's what we are seeing now. Another problem is that in Taiwan, we have a very big manufacturing sector, but they import almost all their raw materials. And without due diligence, then there could be importation of conflict minerals or other problems, and this is also a risk. So it's not just about forced labor or gender discrimination. I think Taiwan obviously plays a very important role in the global supply chain. But the draft action plan only regulates a small number of companies. And in Taiwan, we have a very vibrant chip industry, and we also are developing our defense industry. So we do have HSTC, strategic high-tech products regulation, but we don't have HRDD, human rights due diligence, to prevent Taiwanese machine tools and other components being used in other activities that might violate human rights.
Also, two more people. Yes. Very short.
Hi. I'm again from the Environmental Rights Foundation. And in the previous concluding observations and recommendations, it was mentioned that we need to, in Taiwan, the government needs to set up a national contact point. But that hasn't happened. There's no budget, no people, no contact window. So in the Ministry of Economic Affairs, we see that the national contact point is still not happening. And the COR last time also mentioned that laws have to be devised. And the Ministry of Economic Affairs said that they are still monitoring the development. But what we are seeing is that they are not even monitoring. They don't have any plan at all. Whenever we meet with the Ministry of Economic Affairs, when we talk about mandatory due diligence, then there's no more discussion. And then, as was mentioned by other people, the information disclosure mostly is just a soft guideline. But I think here that means that you're probably mixing HRDD and CSRD. And I think mixing the two is actually not good for human rights governance.
National contact point, whether it was established, whether it is working, whether you receive any complaints, so thank you very much. And then finally, you.
各位委员。
Ladies and gentlemen, good afternoon. I again come from the Tax and Legal Reform League, and in Taiwan, we see that the tax regime is being weaponized. If there is a fake or a wrong tax bill, it can be used to suppress people or organizations. And in the administrative court, such bills can be used by officials. And it often takes decades for people to fight against the state. And sometimes the complainants even die. So this is not justice. It's a kind of torture. And it also violates Article 2 of the Convention, because there's no effective remedy. And we hope that the committee can stand with the people and tell the government what they should do. If a tax case can go on for 30 years, of course, this is not the fault of the current officials, but they should do what is right. So we hope that the committee members can tell the government what they should do. And according to Article 5 of the Convention, the government should not abuse its power. And current officials have the power and have the responsibility to terminate a wrong case. And I think you've all heard about the Taijimen case, but it has not been included in your report. I sincerely suggest that you look into this case. It's been going on for 30 years, and it's not without a reason. It actually reflects the problems of Taiwan. So please include this in the report and stand with the people. Thank you.
Olivia, do you have any follow-up question? Okay, so we have still, 17 minutes. So we will now talk about the gender equality issue. And my question is primarily hearing what government has explained in the morning session. They are trying very hard to change the situation in Taiwan regarding gender equality, which of course is not enough. So if any of you think that government should take any additional measure or in a different direction, I would like to hear what you think, how to bring gender equality in a more quicker way. Yes?
Hi, I come from TAP CPR. So regarding this issue, I think in terms of the current state in our society and also our government, some people seem to think that after same-sex marriage was legalized, then somehow we've already reached some kind of milestone in gender equality. It's true that the legalization of same-sex marriage was a very important milestone. But I have to say that after the legalization of same-sex marriage, gender equality and also the effort to reach gender equality has reached some kind of obstacle. And what I would really want to say is about the protection of sexual minorities.
For example, there is a structural discrimination chain, for example, for transgenders. We see cases that transgender students are not able to live in the dormitory according to his or her sexual identity. So this person finally drops out, unable to finish schooling. And also in terms of employment for transgenders, we heard from the government talking about sexual discrimination. We can see transgender people in the workplace wants to use a toilet according to his or her sexual identity. So they are not recruited by the possible employer. And also, employer asks a bisexual to come out at the workplace to his or her colleagues. And then this employer believes that this bisexual person put in the wrong information on the gender column in the job application form. And then so the employer decided to lay off this person due to this, so-called deception. So we can also see a large gap between the cities and the remote area in terms of cross-gender medical services. So we can see that, a sexual minority is not able to, for example, finish school or have, quality jobs, or is unable to get quality medical services, even in terms of housing. So yesterday we talked about disadvantaged people who are actually poor and unable to turn their life around in terms of their social and economical situation. So how are we going to address this structural discrimination? We hope that the IRC can, in your COR, can ask the government when it comes to policies. Although the government made some gender impact assessment. However, the government fails to do such assessment for sexual minorities. And also one more thing, we hope the government can pass an anti-discrimination act or equality act. Because if we have such acts, then they can talk about, for example, there should be no discrimination against not just gender, but also, sexual orientation and also gender identity. So this will help the LGBTI plus people from being discriminated against. And then also the government can put in more resources. Thank you.
So I see 1, 2, 3 more, 4 more. And we have to finish within 11 minutes. So.
Hello, everyone. I'm from the Alliance to Reform Public Assistance Act. I want to talk about poverty.
Issue in the afternoon session.
Okay. But it's related to gender equality.
Okay, so
So I want to talk about for the Public Assistance Act actually rules out new immigrants who haven't had Taiwanese identity card. And these people are not able to seek public assistance. And lots of marriage migrants are women. And before they have the Taiwanese ID, they may, for example, divorce because of gender violence. However, after the divorce, this person doesn't have a Taiwanese nationality, so this person cannot seek public assistance, so that they actually fall into poverty. And after the divorce, these women, these marriage migrants, their children, so maybe this woman will have custodies on their children. However, these children cannot have direct access to public assistance. So that means that this marriage migrant and the children are not able to seek public assistance, so which caused them into poverty. Thank you.
And then you, and then you.
So I'm from the Taiwan Sex Industry and Workers' Rights Association. So I want to talk about the sex workers being persecuted by the law. Taiwan passed a same-sex marriage law. However, for sex outside of marriage, there are still a lot of criminal and administrative punishment. So this is not on the. They talk about this is a violation of good customs. For example, in criminal law, there is laws related to, for example, abortion or social order maintenance. There are administrative punishment for sex workers and consumers. We hope that in the future, in the Anti-Discrimination Act, we should the government should decriminalize sex workers and full occupation safety and health protection for sex workers. Actually, the government a few years ago for Article 80 for Social Order Maintenance Act, there is an act about punishment on both the prostitutes and also the consumer, the clients. And actually, we think that the government only utilized some of the partial provisions. They only talk about the Taiwanese people support a dedicated zone for sex workers. However, the report says that in the end, the conclusion says that we should promote the decriminalization of sex work and provide more comprehensive sex education resources, but the government doesn't actually adopt that idea. So can I ask the IRC to help us with that? Thank you. Hello, I'm from the Judicial Reform Foundation. We think the government doesn't have enough respect for women's bodies. So a previous speaker talked about abortion. So for our Genetic Health Act, if a minor woman is pregnant, if she wants to get abortion, they need to get the consent from the parents. If you are a married woman, unless your fetus is abnormal or if you are pregnant because of rape, otherwise for a married woman needs to get a consent from her spouse, from her husband. So that means that this doesn't show full respect for women's body. Thank you.
Dealt under Article 12 on health, regarding sexual and reproductive health and rights. Yeah, but anyway, thank you for the information. I saw more hands. So you and any? Yes, very briefly. Yes, go ahead.
I'm from the Taiwan Gender Equity Education Association. I want to talk about sexual equality education. For the Ministry of Education in 2022, talked about want to roll out the comprehensive sexuality education from the UN. However, in practice, we see that education talk about, abstinence and also conservative sexual education. So that means for the past 20 years, in terms of sexual education, we still see some negative effect. And this kind of negative effect can be shown in a few years ago. There is in a junior high school, there is a test on sex education, and there's some bias or discriminative statements or phrases are used in the test. So that shows that that's very inappropriate in terms of rolling out sexual equality. And also for LGBT youth in school, their situation is not optimistic. According to the 同志 Hotline Association, we can see this youth continue to suffer from discriminative statements. They are harassed, or school principals and teachers and the staff, if they can include the concept of LGBTI+. So I think that can help improve the situation of these students in school. So I want to ask the government to continue to strengthen the training for first-line teachers, teachers training, and for schools, principals, and directors. And for cross-gender, although there are certain gender-neutral toilets and environments in the dormitory, however, when we conduct survey, we can see that lots of schools, in terms of administration, they do not understand this kind of concept rolled out by the Ministry of Education. So their facility they set up are not ideal, or they do not comply with the gender equality standards. So we encourage the Ministry of Education, in addition to improve the sexual equality space in school, they also need to provide more, better standards for the administrations. Thank you.
Okay, after her, yeah? So you go first and then.
Hello, I am from the Taiwan Parents Protect Women and Children Association. I want to talk about gender-friendly toilet. The government has been promoting that. However, we can see in terms of, in this kind of gender-friendly toilet, we can see still some females are being, recorded by hidden cameras. So it happens to many universities. So I think there are problems in terms of the policy of the promotion of gender-friendly toilet. It doesn't address the issue of for women to use toilet safely, because we see that it's difficult for women to be able to enjoy their rights to go to toilet. We know that because women actually takes, twice or 3 times the time when it comes to the toilet use. So if the policy of promoting gender-friendly toilets, if it affects our rights to use the toilet, I think the government should address that so that we can have a safe environment and enough toilets for women. So the government should have thorough consideration and planning. We recognize that people of other gender identity have their needs, but I want to ask the government to respect women. And in terms of dormitory, how come there are concerns? It has to do with people's safety. So we need to consider all of those. We respect people's special needs, but at the same time, we need to respect women's right to safety and to privacy. And for men and women, we hope that the government can have a definition that meets international standards. So both genders should respect each other. But when it comes to biological sex, we need to pay attention to the importance of biological sex. Thank you.
And last, please.
1分钟。I'm from the New Vitality Independent Living. So when it comes to women's policy and barrier-free space and the policy for women with disabilities, we think there are a lot of unmet needs. For example, when women with disability, when we go out, we need a lot of assistance in terms of personal assistance, safety assistance, and the use of assistive devices. We encounter a lot of problems. And also for health, for medical services, when we go to hospitals and clinics, there are no good facilities for women with disabilities. So when it comes to individual safety, barrier-free space, personal assistance, and also when we become mothers, in addition to, I think that we should consider all these different needs in different aspects. But I think when it comes to women with disabilities, these services are provided in a fragmented way. And in terms of women's education and also labor participation, I think women with disability have lower participation than regular women. So I think the government should have more intersectional statistics and design policy accordingly so that can satisfy women with different needs. Thank you.
30 seconds. Okay.
I want to respond to about campus space for genders, for gender-friendly toilet. So a previous speaker talked about privacy and safety, but the government had a very clear principle. The government says that the safety and the privacy is the lowest standard. So I don't think there is any concern over that, because in practice, we visited schools and universities, and we see that for single-sex toilet, actually there are more videotaping of hidden cameras from women's toilet. So only 1 in 7 this kind of incidents happen in neutral-friendly toilets. So I don't think it is a problem with having a gender-friendly toilet. And some universities start to roll out a gender-friendly dormitories. For example, the Taiwan Normal University. So the director told us that in their sexual gender-friendly dormitory, they see very good interaction among students, and there are less conflicts happening in this kind of gender-friendly dormitory. So I believe that the establishment of such dormitory is actually beneficial to promoting LGBT plus in Taiwan. Thank you.
Yeah. Thank you very much for all your information provided. We will take into account, but there is a limit, that what we can incorporate into our conclusions and recommendations. So please understand if we cannot take all of your concerns in, nitty-gritty detail. So, but anyway, thank you very much. And then the issues that are not addressed enough, of course, you can raise it under other articles of the covenant, because whether it relates to the social security, family, or health, or education, etc. So we'll see where to address that kind of issue. So this afternoon and tomorrow, we have time to engage again. And thank you very much for your participation. I also thank to the interpreters for your very hard work, although it is not provided in Taiwanese or Hakkai language. Yeah, so thank you very much. In sign language, yeah, he's trying very hard, which is also very difficult. Thank you very much. 谢谢. We will
两公约第4次国家报告
The international review meetings of the 4th National Report on the ICESCR. Session 3 begins now. In this session, we'll cover Articles 6 to 9 and concluding observations and recommendations, paragraphs 42 to 48. Session 3 now officially begins. When you speak, please make sure that you don't speak too fast for the benefit of the interpreters. Before you speak, please identify yourselves and remember to turn off the microphones after speaking.
Good afternoon, ladies and gentlemen, and welcome to the third session of ICESCR. I thank again to the representative of the Taiwanese government for attending this session, and looking forward to your replies to questions posed by the members of the International Review Committee on ICESCR. Likewise, this afternoon we'll have a 3-hour session, and I will propose again that we have a break in between, about 15 minutes, so that we can be relaxed and can go to the bathroom, etc. Yeah. And then afterwards, we'll have, again, 1-hour session with the non-governmental organizations regarding the issues that we will cover. As said by the introducer, we will deal with Articles 6 to 9, which is right to work, so labor rights, and then right at work, which means right to just and favorable conditions of work, and then trade union rights. So that covers 6, 7, and 8 articles of the covenant, and then Article 9 regarding social security. And I think that we'll have plenty of time, and if we are lucky, we might finish even early than 3 hours. So looking forward to frank, constructive dialogue between the committee and the Taiwanese government. So regarding the right to work, I will ask first our member, Mr. Jochen von Bernstorff, to start with, which will be then continued by Ms. Rosalind Noonan, yeah, regarding the right to work issue.
Thank you, Madam Chair. I would like to address the issue of domestic work. And first of all, I would like to acknowledge that Taiwan, as we have also seen in the documents, has a regulatory framework to address exploitative practices in the field of domestic workers, and there have been some improvements over the last years. However, some of the submissions we received raised concerns with regard to the accessibility and effectiveness of complaint procedures for domestic workers, in particular for domestic migrant workers, due to the dependency of migrant domestic workers on their employers, they, it seems, often refrain from using existing complaint procedures, hotlines, and other mechanisms. And we would be interested in hearing your reaction to this concern. The main concern in this field of domestic workers that has also been expressed in the last review is that domestic workers are still excluded from the Labor Standards Act. So they fall under the legally under the Employment Services Act, and there is a considerable difference with regard to minimum wage and also minimum rest periods. So if the information is correct, the minimum wage is significantly lower, and the minimum rest period per day is 8 hours under the Employment Services Act, which means basically 16 hours, potentially 16 hours of work and 8 hours of rest, which seems pretty harsh in terms of working conditions. It's basically the time you need to sleep. So the answer given by the government was that the nature of domestic work does not allow the inclusion into the Labor Standards Act and justifies this the exclusion from this normal Labor Standards Act. So we would be interested in the reasons why the nature of the work does not allow to guarantee these minimum rights that other workers in Taiwan enjoy. That would be my first question.
So you will wait for the replies? Yeah, and then raise another issue. Yeah, okay. Please.
I come from the Ministry of Labor. So regarding domestic workers and their circumstances, I would like to provide a preliminary response. So domestic workers, they work in a household, and that means that it is difficult for the government to intervene when the domestic workers enter a household. So we hope that before entering a household, the domestic workers can already receive information and support. So for employers, before they recruit migrant domestic workers, we already tell the employers the laws that they have to abide by. So that's the information session for employers. When migrant domestic workers arrive at the airport, we'll first take them to a training venue, and there will be a 3-day, 2-night orientation so that the migrant domestic workers know the rights that they enjoy while they work in Taiwan. And we'll also talk about safety issues and also complaint mechanisms. So all this information will be covered in the orientation for migrant domestic workers. And also during the 3-day orientation, we'll explain to the workers what consultation and complaint mechanisms are available for them. So we'll provide the hotlines provided by the government, and local governments will also go to employers' houses for visitation. And when necessary, we'll also provide legal consultation services. And before the workers leave, we'll ask them to add us as their line friend on the line messenger, so that they can receive the latest labor policy information. So that means that every domestic worker, when they come into Taiwan, they can use the Ministry of Labor app. So after they arrive in Taiwan, within 3 months, local government representatives will go to the households with migrant domestic workers to see their working conditions and so on. And if there's something that has to be addressed, the information will also be given to the migrant workers. And lastly, if migrant domestic workers want to terminate the contract, and before they leave Taiwan, will again do a final confirmation to confirm that the domestic workers are not being forcefully terminated and they are leaving Taiwan out of their own will. So these are some of the measures that we take to protect domestic workers. Now, regarding the Labor Standards Act, my colleague will respond to the question. Thank you for the question regarding the rights of domestic workers. So, domestic workers employed by private households indeed are excluded from the application of Labor Standards Act, but this is not targeting migrant workers, domestic workers, I mean Taiwanese workers too. If they work in a private household, then they are excluded from the Labor Standards Act. In Taiwan, a lot of domestic workers actually live in the house of their employers. So regarding working hours and rest periods, let's say what constitutes rest, what constitutes working hours, I think it's very difficult to really have something very clear-cut. So previously, we actually talked to civil society groups. We talked to employer groups and also workers groups. And regarding working hours and rest periods, there was no consensus in the discussions that we held previously. And domestic workers, in terms of their working conditions, domestic workers are excluded from the Labor Standards Act, but other laws, including the Employment Service Act, actually has provisions on the protection of migrant workers, and also the labor contracts are reviewed by the source countries of migrants, and the rest periods and also wages, working hours and so on will be listed in the labor contracts. And we also talk to the mother countries of migrant workers. So I mentioned the Employment Service Act and also labor contracts. And also we also pay attention to the issue of insurance protection for domestic workers. And in Taiwan, there are already provisions in the Labor Occupational Accident Insurance and Protection Act, and migrant workers, domestic migrant workers are also covered by this law. So what we do is that we continue to take inventory of our legislation, and we hope to be able to respond to issues of rights protection put forward by NGOs. And we continue to see how we can improve and implement better provisions.
Thank you very much for the information that you've both provided. I want to pursue this a little bit because I think it's recognised around the world that domestic workers, particularly those who live in the home where they're undertaking the domestic work, are amongst the most vulnerable of any workers anywhere, because they have there's no external oversight. And despite the genuine efforts made by the Taiwanese government to establish some sort of standards or guidelines in the Employment Service Act, from what I've heard you say, there is no actual way of enforcing those, and you have no way of knowing whether or not those minimum standards are being observed. Now, I note that following the review of the Convention on the Elimination of Racial Discrimination, where we dealt with domestic workers, and you undertook consultations with NGOs, as you said, employers, and with some domestic workers themselves, the Ministry of Health and Welfare and the Ministry of Labour, that one of the suggestions that was made by the NGOs was, in order to gather some sound data about what was actually happening with domestic workers, that it would be good to undertake a survey of them, and and use that as a base for developing policies, and for really having some real knowledge of what was happening to them. And I'm talking about both migrant workers, and again, I want to commend the extent to which you've sought to reach out to the source countries of migrant workers and so on. And one of the other interesting suggestions that was made by the NGOs, I understand, was to consider adopting the Japanese dispatch employment model, under which foreign workers are not directly contracted by private households, but are instead employed by vetted professional dispatch agencies, long-term care institutions, or community centres. So, I mean, given that it is challenging to ensure that domestic workers get a fair go anywhere, that's one interesting and practical possible solution that keeps them more protected and less vulnerable. So I'm just wondering, is there any, has any serious consideration been given to undertaking a proper countrywide random survey? And secondly, have you perhaps, or would you perhaps look at assessing, or maybe once you've got the results of that survey, looking at assessing other ways of providing domestic care workers, but without them being so vulnerable in private homes?
Jochen, do you have any additional question regarding the answers given so far? Not yet? Not yet, yeah. Then I will just add a small question regarding this training or orientation at the airport. do you do it individually or groups? Because I guess if someone from China arrives as domestic workers, or somebody from Indonesia or other countries, do you have interpreter? I think for those from China wouldn't need any interpretation, but do you do it individually or do you do it as a group? Because I think that they will arrive separately, not as a group. I don't know how it functions. So can you please provide more information on the method of operation at this airport training?
Okay, let me explain. Well, until now, we do not have any domestic workers or workers from mainland China because of national security problem. So given that we don't have no problem to understand Mandarin, but now, until now, we still reviews, okay? So most of the domestic workers are from Indonesia, Philippines, etc., etc. And as for the question you raised, I would propose, 劳动部, please.
I'll ask the Ministry of Labor, please. Well, thank you for the questions. As for looking at the Japanese dispatch model managed by a centralized organization, we have identified that approach. Actually, starting from last year, we have had a pilot program to provide care services. There are 13 caregiving organizations island-wide. These are NPO, nonprofit organizations. They recruit and train domestic workers of Taiwanese nationality as well as migrant workers. So according to the household in demands, these 13 organizations provide maybe 4 hours or 8 hours or 10 hours services to these households. And they will charge according to the pricing standard formulated by the Ministry of Labor so that this house can afford this kind of services. So we do have that attempt, that pilot program. We will see the results of the pilot program to see whether we should expand the coverage to provide different options for households in needs. Secondly, in our response, we talked about domestic migrant workers. We have 3 days training for orientation. So before they come to Taiwan, we will know every migrant worker, no matter what country they are from. For example, Indonesia, Philippines, Thailand, and Vietnam. For these 4 countries, we will know on what day, on what airplane, who are coming to Taiwan. So at the gate of the airport, we will take these migrant workers to our destination. We will have a dedicated shuttle bus to send them to our training site. So one day, maybe there are 80 or 100 or 200 people waiting to be trained. So we have a collective effort. They will, live and study together. So we have centralized accommodation. And then because we have migrant workers from different nationalities, when it comes to our training materials, we have digital learning. We offer 4 different languages so that we will use their mother tongue to allow them to understand things they need to know about working in Taiwan, how to protect themselves, how to obey the laws, and so on. And after the training, they will they will subscribe to the LINE application of Ministry of Labor, so they will know what kind of services that the government is providing to them. Thank you.
The colleague of the Ministry of Labor has emphasized now our government is trying to some initial plan because we recognize the vulnerable status of living domestic workers at home. So we are now trying to learn from the Japanese model, namely where to import the domestic workers and so we are living in a building right? And well, it will be sent to the family in need. In terms of necessity, so that they can live in together and separate from the family. But it's, as my colleague just said, now we are trying this new model, and the Ministry of Health and Welfare, we are now just initiate the long-term care project 0.3 from this year for the 10 years. And our idea is actually we also recognize now we are facing the shortage of the labor force. So it's probably in the long term, it's probably quite difficult. It's a one-to-one. So we will encourage such a kind of innovative project to reduce our dependence on domestic workers. Okay, thank you.
Okay, so yes, please.
Yeah, thank you very much for these very helpful answers. This new scheme you refer to, will this include a minimum wage that is the same minimum wage as the one that is guaranteed under the Labour Standards Act? So will you try to include those domestic workers in the new scheme, I mean in the long run, into the Labour Standards Act, or will this be still on the Employment Services Act, will you sort of remain or keep the dual track, or will you try to integrate in the long run domestic workers into the Labour Standards Act, which would be probably the requirement under the ILO Convention 189 to have equal standards for all workers, including those doing domestic work and including those who are migrant domestic workers.
Point. You mean is a dual system, or is ILO 189, right? Okay, so please.
这边
Answering your question. So if the migrant worker is hired by institutions, like what we mentioned, we have currently a program that's having organizations hiring foreign workers directly. So you can see this institution is the migrant workers' employer, so they have to follow the Labor Standard Act.
Do you want to continue? Yes.
Under Article 6 and the under the issue of migrant workers, there are like two groups that have been mentioned in particular in the submissions we received. One is workers in the distant water fishing industry, and the other issue referred to students foreign students coming to Taiwan and being somehow exploited in work or labor schemes which are somehow part of their contractual obligations when coming to Taiwan. Maybe we can start with the distant water fishing issue. So there have been, as I could see in the documents, there have been a lot of measures taken by the Taiwanese government over the last years to actually tackle this problem, the exploitative situation of many workers, migrant workers, working on vessels, especially on the high seas. And There is in particular the Action Plan for Fisheries and Human Rights, which we have taken note of, which tried to improve the protection of foreign fishers employed on these distant water fishing vessels. And one of the measures taken were, it seems, increased inspections on the ships, on the vessel. And as I saw in the 2024 Implementation Progress Report of the Action Plan for Fisheries and Human Rights, it is stated that unannounced labor inspection have only started in November 24. So we now, it seems, have 1 year of unannounced labor inspections. So the question is, does this mean that all labor inspections now are unannounced, all of them, or that there is only a certain percentage of unannounced inspections? Because I think this is a very decisive question. Announced inspections are probably less helpful than unannounced ones. And I also saw in the report, in the implementation progress report, that only 50% of all distant water fishing vessels are inspected yearly. So this is only, so the question would be, is it feasible to inspect all vessels, or at least a higher percentage than 50%, and to do these inspections unannounced? Yeah, that would be my question.
Who is going to answer to this question?
I come from the Fisheries Agency under the Ministry of Agriculture. Allow me to respond to the committee's questions. So the Action Plan for Fisheries and Human Rights was indeed implemented by the Ministry of Agriculture from 2022 to 2025. In the Action Plan, we added an additional 60 inspectors, and they inspected about 900 distant water fishing vessels every year. And you asked whether these inspections are unannounced. In principle, when we do have unannounced inspections, specifically because in the previous round of review, we found issues of exploitation or forced labor. So unannounced inspections have their own merit. However, there are certain constraints that make it impossible for us to make unannounced inspections. So for example, when our inspectors go abroad to inspect, it's not possible to just do this unannounced. But in Taiwan, within Taiwan, I think we can try to have 100% unannounced inspections. And then you asked about the inspection rate of 50%. In our action plan, the KPI is 50% or more vessels. And we hope to be able to cover at least 20% of the migrant fishers. And from 2023 to 2025, the data that I have here show that, for example, in 2023, it was 55%. In 2024, it was 73%. And in 2025, it was over 60% inspection rate. And basically, we do risk-based inspection because obviously the government also has limited resources, so it might be difficult for us to cover 100% of the fishing vessels. And that's why we have to take a risk-based approach. Thank you.
I can imagine that how difficult it would be to dispatch inspectors, to the far away sea to have inspection. Yeah. So, do you have any follow-up question? Yes.
Yeah, maybe one follow-up question that was raised also in the documents. The problem of Wi-Fi access for migrant workers on the vessel. It seems that there was a serious problem of workers not being able to communicate with their families, not being able to communicate at all from these vessels on the high seas. And given the fact that these vessels stay there for a very long time, I think up to 9 months, if I have understood this correctly, on the high seas, this is a serious problem. And I saw in the action plan that the government wanted to take measures, and I would be very grateful for more information on this very important measure to ensure Wi-Fi access and as I saw from the submissions, Wi-Fi access that is not controlled by the captain of the vessel. So if Wi-Fi access is controlled by the captain or by the crew, by the other crew of the vessel, then there might be problems that the migrant workers cannot speak freely and cannot complain. And so these are concerns raised in the submissions. Maybe you can respond to this.
Anybody would like to respond to this Wi-Fi issue?
So regarding this question, I come from the Fisheries Agency. Allow me to briefly respond to the question. So regarding Wi-Fi installation and access, the Taiwan government takes this issue very seriously. In recent years, we've been very proactively trying to push for the installation of Wi-Fi on board. But here, we also need to give you some contextual information. Now, Taiwan, if you want to use Wi-Fi on fishing vessels, usually you have to use satellites. But of course, in terms of communication means on board, it's not just satellite. You can also use radio or satellite phones and also Wi-Fi. Now, regarding Wi-Fi, I think people do see Wi-Fi as a better solution. But to provide Wi-Fi access on board, you need satellites. And previously, in terms of the hardware environment, we only had a high orbit IMSAT satellite, and it was very expensive, and it also had coverage issues. In recent years, we have a OneWeb low orbit satellite that is going to be introduced, but this is not yet accessible to private companies. So satellites satellites like Starlink, for whatever reason, Starlink is not authorizing Taiwan to use its service. So we do face some constraints in the hardware environment as well. But even with these constraints, we are still trying hard to promote Wi-Fi access. So previously, we provided subsidies for Wi-Fi equipment installation, and then we also provided subsidies for communication costs. And then we also launched certain incentives through administrative means. So, for example, fishing vessels with Wi-Fi on board can have more days operating on the high sea. So something like that. And currently, after the first phase of the action plan, 185 fishing vessels now make Wi-Fi available to the crew. But of course, 185 is only a proportion of all the vessels. But we are continuing to work hard to make Wi-Fi available to more fishing workers. And in 2025, last year, we in fact published guidelines regarding the use of Wi-Fi by fishing crew. So this is basically for the management of Wi-Fi use. But regarding the guidelines, we are still receiving feedback, and we are continuing to review the guidelines. And we hope that the use of Wi-Fi on board can be something that not just satisfies the fishers, but also the employers, because sometimes the employers may be worried about certain confidentiality issues. But of course, this is not an excuse not to provide Wi-Fi to fishers. So in the next phase of the action plan for fisheries and human rights, we'll continue to provide subsidies to ship owners so that they provide Wi-Fi to fishers. And we hope that more fishing vessels will have Wi-Fi on board. And perhaps when the number reaches a certain point, then it will become a fixed feature for all fishing vessels. The review committee mentioned that sometimes Wi-Fi can be controlled by the captain. So we are not just providing subsidies for Wi-Fi installation. If we provide subsidies, then we also ask fishing crew to sign a document basically testifying how much time they got to use Wi-Fi for. And also we inspect about 50% of the fishing vessels. And for fishing vessels receiving subsidies for Wi-Fi, we also ask crew members to see whether they did get to use Wi-Fi. Now, if fishing vessels receive government subsidies, then they have the obligation to provide Wi-Fi access to fishers. And also, I think with Wi-Fi, I think sometimes it's difficult for the captain to control all access to Wi-Fi because of the feature of the technology.
Thank you very much for this very helpful, also contextual information on the technical problems. I have a more general question regarding this whole area of rights of workers on these distant water fishing vessels. If I'm not mistaken, all the measures you have taken within the last years are based on administrative action plans, or perhaps also some regulations. So I didn't find a real law, legislation, formal legislation for this whole area. And the whole area of distant water fishing is, from a human rights perspective, because of the scale and the quantity of violations, as you also said, it's a problematic area. And did you consider to enact an overall protective legislative framework for this whole industry, rather than basing all the measures on administrative action plans, because they can be revoked very easily. You know, with a new minister, the whole legal protections you have been working on for over the last years can be erased very easily if it's only based on regulation and administrative action plans. So is there an attempt to come up with the legislation for this whole area of distant water fishing and human rights?
Who's going to answer that?
Fisheries Agency. Well, thank you for your concern for distant water migrant fishers in terms of specific regulations. For in fact, in our Act for Distant Water Fisheries, it stipulates the protection of distant water fishers. So there are some protection in principle. Of course, the extent of protection is limited. With regard to the international development, especially the ILO 188 Convention, we are now in the process of incorporating this convention into the domestic law. So we have a draft of the Implementation Act of C-188 Convention. And we have been through a lot of discussions in the administrative agencies last year. And we already have a direction. And after we submit the proposal to the Legislative Yuan, we can offer a more comprehensive protection to distant water fishers. But still, coming back to the action plan for fisheries and human rights. So this is a comprehensive protection mechanism which covers a lot of government agencies, including the law enforcement, the level of monitoring. Hopefully, in terms of the protection of distant water fishers, we can, in addition to the aspect of the law, in terms of execution, we can also strengthen our efforts.
Timeline for enactment. Again, the issue at the Legislative Yuan. So you don't know? Maybe it didn't go through the...
是，这个法哈，目前大概已经
So we have completed the draft. And later we will submit to the Legislative Yuan. In terms of timeline, we have no control over that. It still relies on the legislators' negotiation on this.
Should have timeline when to submit to the Legislative Yuan. When are you going to finish the drafting? Do you have timeline within this year or?
So it still requires some administrative procedures. So the administrative department is doing everything we can so that we can complete the procedures.
Let me explain. So far, I know now the ministry they have already they have already a draft, And now I think no more than 6 months, and then we will send to the administrative year, right? And after the process, we will send to our parliament. But now we don't know. We don't know what will happen in our parliament. Who knows? But at least from the administrative, we have already have a draft. Yeah.
So you have a draft, and you will finish the administrative procedure, and it would be safe if we expect that within this year, at least, the Ministry of Agriculture will finish and then send it to the legislative yuan, which is now, which will be then in the hands of, okay. All right, let me ask just one small question regarding this distant water fishing and labor inspection. Have you found any case of trafficking after inspection, which involves criminal offense? Has there been any cases of finding labor trafficking, whether it's Indonesian fishermen or... Yeah, that would be my question. After inspection.
Thank you for the question. From 2023 to 2025, after inspection, we have received reporting of suspected human trafficking or forced labor. In 2023, we submitted 7 cases. In 2024, 5 cases. In 2025, so far 0. So for the past 3 years, altogether 12 cases.
So this will conclude on 2 issues regarding domestic migrants and distant water fishing. Any other issue you want to raise? Yeah.
Yes, I'd like to raise the issue of sex workers because, again, in the context of current Taiwan law, sex workers are not, will in fact face very significant discrimination because they're not included, they're not recognised in the formal labour laws, and you know, this leads to them being, I mean, there's discrimination, there's social stigma, I think, but very significantly, you know, they can be denied housing, you know, they experience financial exclusion and loss of child custody, among other things. So the issue is, and at the moment, the provisions for sex workers, which, as I understand it, they're limited to particular zones, but not every local authority actually provides zones. Whether or not zones are appropriate is another question. So essentially, they're very limited possibilities to operate semi-legally in assigned zones, and then even if they do, there are no protections, effectively no protections for them. And I think that amongst sex workers, trans people, transgender sex workers, face particular challenges. So one of the proposals, and earlier this morning we were discussing the overarching anti-discrimination law, and what I want to raise is the question, you know, I think that the example of the sex workers brings into sharp relief the importance of having some provision relating to non-discrimination on the basis of employment or occupation in the anti-discrimination law. And I think it's also, so I'd, like to get a response from the government to that. And also, again, to what extent there's consultation with sex workers about the issues that they face and any, what are their mechanisms for making, complaints when they face discrimination, or other barriers, and what is under what conditions are transgender people generally, who constitute a tiny proportion of the population, what are what's their right to work? How do they experience the right to work, and to what extent are they able to find employment without discrimination? And I really raise this because, because we've received representations in the submissions, but I'm also very conscious because in the New Zealand context, when I was at the New Zealand Human Rights Commission, we undertook in the 2000s a review of the discrimination faced by transgender people, and it was shocking, and a lot of it's invisible, as is the ill treatment that sex workers receive when sex work is not decriminalised. So, and whether we want to acknowledge it or not, sex work occurs everywhere, and providing there are strict rules on underage, preventing children and young people getting involved, I think we need to recognise the agency of adult women, and sometimes it is exploitative, but not if they experience this appropriate labour protections, which other workers do as well. So that's, I'm just throwing out these questions in relation to this area.
Thank you for that question. If I just add one sentence, the information we received from the sex workers say that they are not getting labor protection, but they are imposed by the tax office. So when they should pay tax, tax office find them out, but they are invisible when they should be protected in terms of work. So who is in charge of this group of people? Ministry of Labor or Ministry of Welfare and Health? I don't know.
Do we have representative from Gender Equality Agency?
有没有 Okay, I try to answer. I would recognize that the sex workers, as you just emphasized, is also one part of human rights, and they are workers, and they also pay the tax. So they should be eligible of the equal rights. And later I will find out who are in charge. Well, someone told me it is the Ministry of Interior, the police, and someone said it's the labor or is welfare. Okay, anyway, I will find someone. Okay, but as the representative of the government, I recognize. But now the problem, because I earned my PhD in Germany, so far as I know, in Germany, and some federal, they have some special act for the protection. Or, I mean, maybe we can find we should find some way to legalize this protection. And I would say, well, this is their rights, and they should be equally treated in this society. given their free will. Okay, thank you.
Yeah, so can I say thank you very much for finding out who deals with this? Because, of course, I mean, one of the issues for sex workers is most often the government agency that they come in contact with is the police, and they're not always treated very, very well. And I think that it's worth, having a look at the different approaches to ensuring that sex workers are not, subject to mistreatment and so on, and discrimination. And there's a variety of ways of which decriminalisation is, I think is definitely worth looking at alongside whether you need special legislation or not, but just simply bringing them into the workforce and enabling them to have the same protections within certain, with certain limitations can be one way of dealing with it.
Deputy Minister, can I ask you that you find out by tomorrow, and then if you can give us some information in written forms, either from Department of Gender Equality within the Executive Yuan or from the Ministry of Interior, from the police, whoever, regarding the policy and then the situation. Thank you very much. Yep. All right, so we dealt with all the issues regarding Article 6 or...
Thank you, Madam Chair. I would like to raise one last issue concerning the right to work under Article 6 of the Covenant, and that concerns asylum seekers. According to the Employment Service Act, Article 51, refugees who are authorized to reside in Taiwan have access to work. But until they are granted residence, which I assume goes hand in hand with their recognition as refugees, when they are just asylum seekers, they don't have access to the employment market, which results in a situation in which they depend entirely on social assistance without any ability for them to seek employment. And if they do seek employment and are discovered, they may be deported as a result. And I wondered whether this was a sustainable situation. In fact, one could argue that if we want them to be self-sustaining in the period during which they are waiting for the right to reside, having the possibility to have access to employment would be desirable. So that would be my question under Article 6 and the right to work, and then I'll have questions on Articles 7 and 8 we'll turn to later.
Is Taiwan generous enough to give employment to the asylum seekers?
Perhaps the Ministry of the Interior can respond first. Ladies and gentlemen, good afternoon. I'm from the Immigration Agency under the Ministry of the Interior. So for asylum seekers in Taiwan, now, according to the Public Assistance Act, refugees can work, but for people seeking asylum, we do have some difficulty in providing access to employment. As we work on a Refugee Act, we are still trying to forge a consensus within Taiwanese society. So we, at the Immigration Agency and also the Ministry of Foreign Affairs, will see why the person is seeking asylum, and will also ask experts to be part of the review committee to see whether the person can be granted asylum. And it's true that this process can be lengthy, so some groups have mentioned the issue of employment. Now, some people seeking asylum actually enter Taiwan legally. For example, they are studying in Taiwan and so on. But of course, there are also some other situations. And the Ministry of Labor is also coordinating with us. So we are thinking about whether we can provide some basic assistance to the people waiting for their asylum application to be approved. Now, I'm from the Ministry of Labor. So as was mentioned earlier, the Ministry of the Interior needs some time to review the documents for asylum application. So before the people are granted refugee status, they cannot work legally in Taiwan. Now, we do know about this situation. So previously, we worked with the Ministry of the Interior. And the Ministry of Interior gave us a list of people waiting to be granted refugee status. And then we also provided this list to local governments. If local governments found that some of these people are working illegally, then they can apply to be exempt from penalty. I come from the Ministry of Welfare, Ministry of Health and Welfare, the Department of Social Assistance. So for us, we provide public assistance to Taiwanese nationals. So people seeking asylum, but if they are of a foreign nationality, then they are not yet eligible to be covered by the Public Assistance Act, but local governments and NGOs may provide assistance.
Thank you. So I have one question to the Ministry of the Interior and one question to the government, whomever wishes to answer. My question to the Ministry of the Interior is, what is the average duration for the examination of asylum claims, right? Between the moment when people file a claim to asylum, seeking to benefit from the status of refugee, and the moment that status is awarded, how many months elapse? And then, if I understand correctly, the answer from the Ministry of Health and Welfare, these people have no access to public assistance under the Public Assistance Act, and they depend, you said, entirely from NGO support. So I'm very concerned by the destitution that these people may be facing and their complete dependence on charity.
And maybe how many asylum applications you receive for refugee status a year?
I come from the Immigration Agency. So regarding the review period, there are 3 stages. The longest time is to verify the reason for seeking asylum. For example, someone claims that he was being persecuted in a specific country, and we need to check whether that's real. So in addition to the information provided by the applicant, we also need to use diplomatic channels to try to gather information. That's why it may take some time. So that's basically stage 1. And stage 1 alone may take 12 months. And then we also have to look at the data itself. So it's around 12 to 18 months. But we can come back to give you more information later. Sorry, there was another question. Right, so overall number of cases. In recent years, now starting last year, there were more people, and usually it's about 20 cases a year. So currently we are looking at 70 cases, and we've already completed review for 15 of them.
I know. Now, what Taiwan is confronting is, is a great pity. We still do not have an act. So for recognizing and for just applicants procedure, I would have said, well, we still lack. So, but we confront the problem since about 3 years ago from Hong Kong. But now our government also faces the problem. We cannot distinguish if they are spy or not. I'm sorry, I have to honest, right? So for this, it takes time. It takes time for reviewing process. And as Mr. De Schutter has raised, is during his application in Taiwan, he will need, first of all, social assistance, and secondly, the employment. So now our government is still discussing about this process, but I personally recognize during this process is still very reliant on this NGO, namely the local governments, charity assistance. We still do not have very systematic measures for addressing this problem.
Yeah, now we turn to Article 8, 7 and 8. Yeah, 7 is right at work. Yeah, and then trade union rights. Yeah.
So Article 7 of the Covenant concerns just and favorable conditions of working conditions. And here, I would like to seek one clarification following the very helpful exchange we had already on the Minimum Wage Act that entered into force in 24. Sorry, this is the act was adopted on 27th of December 2023, and my question is very simple. We know that this legislation establishes a tripartite minimum wage deliberation committee involving unions of workers, employers, and the government, and that they review regularly the level of the minimum wage in accordance with the Consumer Price Index, and we had very helpful explanations about this. My question is this: what happens when the Minimum Wage Deliberation Committee does not agree? So, for example, the unions claim that the minimum wage should be raised by X%, and I know that today it's 29,500 NTS per month. But what if the unions claim that it should be raised further and the employers and the government oppose this? What happens? The minimum wage does not evolve as a result in the absence of an agreement between these parties? And if so, is this not a problem when inflation continues to rise?
Thank you for the questions. So as you mentioned, we currently already have the Minimum Wage Act. So we already have a piece of legislation. In Article 10 of the law, it stipulates that the deliberation needs a quorum of half of the committee members. And so the law itself already provides certain provisions for a situation where there's no consensus within the committee. But based on the previous experience, workers and employers have been able to discuss with each other in a peaceful manner. And there's also mutual understanding. So far, I have to say that in the 2 years after the Act went into effect, we haven't encountered a situation where the committee members don't agree with each other. And you also mentioned inflation. The Act also has provisions regarding the indices used to set the minimum wage. So there's the CPI, the Consumer Price Index. This is, of course, linked with inflation itself. So CPI is something that we have to look at. When we review the minimum wage, the committee members have to look at inflation, they have to look at CPI, and so on.
Thank you very much for this explanation. But so I understand that since the 2 years and almost 2 years and a half the legislation was passed, there was no disagreement within the Minimum Wage Deliberation Committee. But what if there is disagreement? What does the law say? I couldn't find the minimum wage law despite my searches. So you mentioned that the quorum was 1/2 of the members should be present to validly deliberate. But my question is, what if one or two parties disagree with the other, right? Where there's no agreement within the committee. Does the executive one have the authority then unilaterally to raise the minimum wage to ensure that it remains at a decent level or not?
For your question, for minimum wage deliberation, for our situation for the past 2 years in terms of deliberation, as you mentioned. So labor representatives and industry representatives, in terms of the increase of minimum wage, the extent, the percentage, they may have differing opinions. But so far, for the past 2 years, according to our experience, the participants will discuss the economy and all relevant indicators. So participants have thorough discussions first. So after they reach a consensus to increase the minimum wage, so different parties will propose different degree. For example, labor representatives want more, and the industry representatives will, of course, hope not so much. And then they may have differing opinions. However, and the minister is actually the chairperson of the deliberation commission. We also have 4 representatives of experts. We also have 2 government representatives from the Ministry of Economic Affairs and also the National Development Council. So when it comes to extent of increase, there will be a process for full discussion. And then in the end, a extent of increase will be proposed for the participants to evaluate. And so far, for the past 2 years, there is no individual parties or participants saying that it's an absolutely no to increase the minimum wage. There is no such opposition from individual participants. So of course, there will be different, members of commission every year. Maybe this will happen in the future, but not for the past 2 years. And for the procedure to submit to the executive yuan, the law requires that the decision need to be sent to the executive yuan for deliberation. However, in Article 13 of the Minimum Wage Act, stipulates that, for the executive yuan when to make announcement and then what to do with disagreements. So they are relevant, provisions in the act.
Very simple. Well, your question is decision rule. Well, according to the law, it's a majority rule. It is not like EU. Yeah.
No one has a veto.
Yeah, right. So it's a majority rule.
I can ask, this composition of this committee, how many are from workers group, how many are from employers group, and how many are the third party, including the government and then the experts and the development council, National Development Council? Because I think that numbers matter.
我们目前呢，委员
There are altogether 21 members, 7 out of which are from labor organizations, 7 from employers. So it's the same, 7 each, and 4 members from experts. And also for the rest, like I said, the minister is the chair of the committee. There are also 2 from the National Development Council and the MOEA, so altogether 21.
It is often the case that workers group and then employers group, the representative are confronting with each other, and then the third party, so the public figure, experts really controls, manages, and trying to reach. Sometimes there is overnight strike, or confrontation throughout the negotiation throughout the whole night. And it is very tense and sometimes very difficult to come up with a compromise. But anyway, thank you for the information. I think it's a proper time to have a break, yeah? And then we will come back to deal with Article 8, trade union rights, and then also Article 9 for the remaining time until 5. Okay, so we'll have 15 minutes break. All right, the meeting is suspended for time being. All right. Is it okay that we resume our meeting? Now we are going to cover Article 8 on trade union rights, and Mr. Olivier de Schutter will raise questions.
Thank you, Madam Chair. On Article 8 of the International Covenant on Economic, Social and Cultural Rights, which concerns union rights, I would like to raise two issues. The first issue concerns Article 10, paragraph 2 of the Collective Agreement Act, which is one issue we raised in number 24 of our list of issues. This provision of the Collective Agreement Act provides that collective agreements in public enterprises and schools must be approved by the superior competent authority. And we asked about the possibility of the superior authority to oppose certain collective agreements, the grounds on the basis of which such a veto could be exercised. And the response of the government, I quote, says that this requirement exists to ensure smooth government operations and prevent disputes. By screening for inappropriate agreements, the law protects the quality of public services. Therefore, the provision remains necessary and should not be abolished. And we were also told in the responses of the government that in the past 5 years, no collective agreement was rendered void due to disapproval by the competent superior authority. Now, we were presented with evidence that in some cases, at least, there has been such opposition. For example, in a collective agreement that was agreed by the National Donghua University, which the Minister of Education excluded to approve. So I assume that the allegation of the government that there was no disapproval by a competent superior authority is based on the fact that when a collective agreement is negotiated and agreed to before being submitted to the competent superior authority, it does not appear officially, and thus there is no trace of that disapproval. I wondered whether there was any comment on this interpretation I'm trying to make of the position of the government. My second question is a very concrete example, but may be useful to address because it may highlight a more structural problem. It concerns migrant workers resorting to strikes or protests, and in particular, in one example, the Taibo Technology Enterprise Union apparently was prohibited from forming a union with migrant workers in the regulations adopted by the company's internal management rules that excluded, I quote, groups of small groups, I quote literally, demonstrations, strikes, failure to comply with the company's complaint channel to the government, until complainant and I can't read, it's too small font. But anyway, what I would like to raise is when a company has internal regulations prohibiting workers from organizing, which remedies do these workers have against such prohibitions? And I was presented particularly with an example from the Taibo Technology Enterprise Union. So these are my two questions. Thank you.
Okay, thanks so much for your question, Mr. De Schutter. I think it concerns to collective bargaining power rights, right? So 那么请劳动部。
Okay, 劳动部。
I come from the Ministry of Labor. First of all, I would like to thank you for your questions. So regarding collective agreement, we provided information saying that there was no collective agreement being rendered void due to a disapproval by the competent authority. And we also explained that the law cannot be revoked because sometimes the agreements made by public entities involve budgetary and personnel issues. So that's why this requirement exists to ensure smooth government operations and prevent disputes. But in practice, during negotiation between labor and employers, there are also experts on site who can provide information as to whether the agreements may be in violation of the law. So the final agreement usually already complies with laws. That's why there's no case of the agreement being rendered void. Now, National Donghua University and Ministry of Education, I think this is a very special case. As far as I know, they are still in the negotiation process. So please allow me to find out more before I could give you a more concrete answer. And regarding Taibo, and indeed, we know that there's a union of foreign workers, and this union has certain disputes with the employer, and the union organized a vote to organize a strike. Now, if they get the right to strike legally, then of course our country's law will protect their rights to strike as well. And regarding prohibition of labor union organization, in our country, we already have a mechanism. If unions tell us that their employers if they tell us that their employers are prohibiting them from forming unions, then employers will be penalized and also fined. So this is to protect workers' right to organize.
Maybe two very short follow-up questions. First, on the example of Taibo Technology Enterprise Union, could you refer us to the specific provision that penalizes, if I understand correctly, the employer that prohibits unions from operating? I would be interested in having the exact reference, protecting the right to strike in essence, and the right to form unions. And the second follow-up question I have is it correct that the reason why the government in its answers to the list of issues says, I quote again, A review of the past 5 years reveals that no collective agreement has been rendered void due to a disapproval by the competent superior authority. Should I understand this statement as the result of the fact that before a collective agreement is signed, informally, someone from the ministry says this will not pass, and so you should not sign it, explaining that there's no formal veto by the competent superior authority, such as the Ministry of Education, when in fact, collective agreements will be discouraged from being passed, given that the veto is expected, if you see what I mean. In other terms, Article 10, paragraph 2 of the Collective Agreement Act may be a problem even if there's no example of a veto being exercised by the competent superior authority, if there is a chilling effect on the passing of certain collective agreements resulting from the fact that before the agreement is signed, there's an advice not to go further.
Regarding your follow-up question, let me respond. I'm from the Ministry of Labor. So regarding the penalization, this is from the Union Act and also the Collective Agreement Act. So, for example, employers try to interfere the running of the union, or employers try to prohibit the organization of unions. So this is Article 35 of the Union Act, and the penalization is in Article 45 of the Union Act. This system has been running for about 15 years, and there have been cases of penalization. So in addition to the penalty, we also publicize the names of the companies. So basically, we do this to try to protect workers' right to organize. And regarding collective agreements, when labor and employers discuss their agreements, we in the competent authority, of course, respect both sides. But if the employer is not negotiating in good faith, we'll also address this issue. But whatever the content of the collective agreement is, it has to comply with the laws. And if they uphold this principle, then this collective agreement will not be rendered void by the competent authority.
So we are now finished with Article 8, trade union rights. Now let's turn to Article 9 on social security. So would you like to raise the question?
Thank you. Yesterday we raised in broad terms the issue of current social security support for people in living in poverty, for people in serious need of assistance, and particularly highlighted, regardless of any other issues, what appears to be the main barrier at the moment to effective support for those in most need, and that is the requirement of the Public Assistance Act that household income and assets be aggregated in assessing whether an individual is entitled to any assistance at all. I'll come back to that in a minute because, as I say, we did raise that yesterday. But what I wanted to highlight was another issue that has been raised in submissions to us, and that is from people living with disability. And they have pointed out that the financial assistance available to people with disabilities, they describe it as highly inadequate because it does not take into account the additional costs associated with disability, which are very real and which are often higher than those faced by the general population. And, and at the same time, what we know in most places, including my own country, is that people with disabilities usually are in the very lowest group of income. Their income levels are usually at the very bottom of the pile, and that they have a great deal of difficulty accessing secure employment, and that often in order to be able to participate at all in society, which is what the Convention on the Rights of Persons with Disabilities requires, it's about ensuring that barriers are removed to participation by people with disabilities in all aspects of society, that they might require personal services to assist them, and they might require particular technologies, which if they have access to, they can undertake employment, they can contribute to society by earning a living, but they also need accessible housing, which again in most places is in very limited supply, including here apparently. So they're arguing very much that the deemed income and the household-based calculation leaves most people with disabilities in an extremely poor state from an economic point of view, and that fits with the more general concerns that the way in which the Public Assistance Act is currently applied often means that very poor family members themselves are really required to provide assistance to somebody who is who has no income and is in need of support. Or, we've been given case studies of, very elderly people being required to provide support for other elderly people and no account taken about whether they actually have the capability, personally, emotionally, or physically, to do that. And the very responsibility resulting in serious impoverishment for them, as well as not appropriate support for the person who needs assistance at the time. So, obviously, we heard this morning with respect to the tax take as compared to other countries, and I'm not focusing on that at all. My colleague's the expert on that, but I am coming back to the issue that's been raised previously, and that increasingly, given the levels of poverty and the gap, the real inequality that, despite everything, exists here in Taiwan, as it does now in most other developed countries, that household aggregation before support is provided and the way in which it's calculated is hugely problematic and really means that Taiwan is not meeting its requirements to provide social security as required in the Covenant on Economic, Social and Cultural Rights for those in need, whether unemployed, with disabilities, etc., etc. So, so my question is, or our question is there a recognition that the state has a responsibility to address issues of real poverty, such as these, and is it prepared to look at changing the household aggregation process and reverting to an assessment of the individual needs and providing on the basis of individual need, not on the basis of household aggregation.
Thank you for your question. So the question is regarding the system, yeah? How you assess the needs and then who can provide to whom for what, etc.
Well, thank you for your concern. Indeed, financial stability is a very basic requirement for individuals and the families. So I will try to answer all the questions. In Taiwan, in our social security system, we have social insurance, including labor insurance, national health insurance, occupational insurance, national pensions, and so on. So we can see social insurance covers the most population. We have social insurance as the main pillar and also social stipends as a supportive pillar. And then we have social public assistance as the last resort. So social public assistance doesn't equal to social security. What about the poverty, people in poverty? What is the population of people in poverty in Taiwan? We did some discussion in the morning. If you look at the OECD's definition, so if you look at the median income for disposable income per person, if you look at the Public Assistance Act, the definition of low-income family according to the OECD, we can see 60% of the disposable income. So we have, a wider, we have, a more flexible, more loosened definition than OECD. However, if you look at the tax burden ratio compared to other countries, our tax burden ratio is lower. And there are also some limitations on a person's real estate and the movable assets. So if you look at the low income, according to the Act, there are about 500,000 people who are low-income family, about 2.17%. These are the low and the middle to low-income family. But we also provide social stipends, so there are economic thresholds, and the government spend money to provide subsidies to these people. So if we put them all together, and the government is actually taking care of 1.9 million people, accounting for 8.14% of the total population. If we talk about the OECD poverty rate, we compare with the international community, and then our number in Taiwan is about 7.57%. These are the poverty rate in Taiwan. So social stipends and the public assistance take care of 8.147%, and the poverty rate in Taiwan is 7.57%. Of course, we cannot be self-complacent, but you can see the comparison between 8.14% versus 7.57%. And the second issue is that in Taiwan, we use household aggregates as a threshold to evaluate whether this person qualifies for low income or low to middle income family. We know that different countries have different calculation methods, and every country has a different tax burden ratio, and different country has different social beliefs and value systems. And in the civil code in Taiwan, there is a regulation that says that linear relatives should to support each other. And also, in our Social Security Act, we can see under Article 3, it talks about, we are not saying that, the family's responsibility should be shouldered solely by the country. And in the family members, in terms of the family member count, we do not include all the distant members. We calculate, the individual, him or herself, the spouse, and the linear relatives or relatives who live together. And then, or when you file an income, you say that you support these people in your family. So the government consider all of this. We know that there is a lot of change in family type, and there are a lot of complexity. So in a Public Assistance Act, in Article 5, we rule out special situations. For example, people who are not Taiwanese national or spouse from mainland China, they're excluded. Or if they do not live together, or they do not actually support, and then we will exclude them. Or people who do not have the capability to help to support their families, or linear relatives who are already married, they are excluded. Or for example, their parents who do not have the obligation to support, or for example, family member in military service who are gone missing, or who are in prison. These are all excluded. So the county and the city government will evaluate. So for example, if this person really has some special situation, so this person is not able to support his or her relatives, so these will be excluded as well. So we have all these exclusion provisions. And for our amended version, we will continue to relax. For example, some linear relatives who do not live together, their houses and their assets, their land, their houses will not be included. So that means we are providing a more flexible, we are loosening up the definition so more people can be taken care of by the government. And for the imputed income, actually, there's no such term in our law, but because of certain historical background in Taiwan, how come in Taiwan we have the imputed income system? This is because that in terms of Taiwan's tax system, actually this is not very comprehensive. Some people work, they have a job, but we don't know how much they earn. And there are also, like street vendors or informal workers. They do not have labor insurance, and we don't know how much money they make because there's a lot of shadow economy in Taiwan as well. So that means it's going to pose difficulties for the government. And we also refer to other countries' experience. Those countries have very powerful information system, database. And then for us, Taiwan, cannot compare to those countries. But still, there are people who say that they do not generate income. They do not have a job. If we do not impute their income at all, there will be some, conflict between these people and the Ministry of Labor's efforts to help these people to get a job. So the imputed income system means that when we evaluate the applicant household, we encounter some difficulties, but at the same time, we want to balance. We want to encourage these people to find a job, to work, because this will be beneficial to your family income. And because of these multiple factors, we have to adopt this calculation method. So I want to explain the historical context to the IRC. That is why we have this system in place. And during this amendment, we for multiple occasions, we discussed with civil society. We know civil society is very important in terms of helping the society to improve. We know that indeed there are some vulnerable people who are finding it very difficult to find jobs. So maybe in our imputed income system, we estimate their possible income, and we heard their voices. And during the amendments, there is one expert giving us suggestions that we should look at Article 24 of the Employment Service Act, talking about certain vulnerable groups who find it difficult to find jobs, or in terms of compensation salary level, their salary is relatively lower. So we also refer to Article 24 of the Employment Service Act to consider these vulnerable groups. We do have some, formula for calculation, but their imputed income will be lower, maybe only 50 to 80% of their income. So we give them a discount of their possible income. So this can help them to be qualified for the application. And then this time, we are relaxing on the requirement on, for example, age. For example, we can extend all the way to 55 years old, or women, stay-at-home mom who want to find jobs again, or long-term unemployed people, or ex-prisoners. So we have loosened up. We provide more flexibility. So we consider the Taiwanese context, but we also consider the situations of these vulnerable groups so that we can broaden our scope for care. So we're also discussing with the Ministry of Labor to see these people who have working capabilities but who are vulnerable. We want to help them to be able to find jobs. And for whether people with disabilities receive assistance, in our documents, we can see that for 1/4 of the low-income qualifiers are people with disabilities. So for the applicants' financial possession evaluation, we can see most of the people with disabilities do not have working capabilities. Because we know not all of them, some of them are still able to work. So we will use 55% for the calculation for people with disabilities. So that means that they can help them to be qualified for public assistance. So that is what we do for people with disabilities in terms of Public Assistance Act. And of course, for people with disabilities, benefits or Rights Protection Act, there's one provision about their economic financial security. We can see that here we have, relaxed the requirements for people in this act. So I will ask my colleague to add you to provide the information. I'm from the Social Affairs Agency, from the MOHW. So I want to talk about what we do, what kind of system we provide to people with disabilities in poverty. So in Taiwan, there's 1.25 million of people with disabilities, and then 30% of them receive subsidies, and the amount they receive range from, we can see 9,485 and 4,049. So we relax our requirements so that they can receive assistance according to their situation. So in addition to low-income families assistance, and the stipend I provide, I'm talking about here, can be stacked upon the first assistance I mentioned. So they can have two sources of assistance so that they can maintain their basic living. And secondly, for regular people with disabilities, so we have, in our national pension system, we have a basic protection pension for people with disabilities. So this is basic guarantee for regular people with disabilities, not poor people with disabilities. And also for assistive devices and so on, we do provide subsidies of assistive devices for people with disabilities. We have about 215 types of of devices provided to people with disabilities so they can maintain their basic life. In terms of long-term care, we have subsidies for assistive devices. So a person with disability can apply for, long-term care, and also for people with disability care, and also at their workplace, there are different types of assistance. So we have 3 types of assistive devices program for people with disabilities. And also there's another question about, these people have a more difficult life. They have more financial pressure because they need to spend extra money on care, and the government also pays attention to that. So for low-income to middle-income family, when it comes to long-term care, they don't need to pay for co-payment. They don't need to pay out of their own pocket. They can use long-term care services for free. If they go to daytime care center, if they go to the institutions, we also provide subsidies. So that means in terms of their daily life, they can maintain the same level of living condition. And also for people with disabilities, whether they can have social insurance, because in terms of social insurance, people need to pay out of their own pocket. And then for disabilities participating in social insurance, we provide subsidies for their premium. For example, for severe level of people with disability, in terms of national health insurance premiums, you don't need to pay at all. And then the government pay about $4.2 billion on this.
Well, yeah. Well, first of all, thank you for all that information, which was also pretty much provided in the reports from the government. So we have had access to that as well. My concern is that we have also received very thoughtful, detailed submissions about the actual situation of people living in very, very poor circumstances, and the assistance that they receive. Well, assistance in some cases actually being denied because of the household aggregation process, and in other cases being so low that it absolutely does not allow people to maintain a decent minimum standard of living. So there, I think, and I'm sure that you recognise that to some extent, that there are still significant pockets of real need that are not being met by your current system. But the question that I actually wanted to ask, which is, having read the information about how the system works at present, as well as the NGO submissions about it, it strikes me that it's enormously complex, and I'd be very interested to know whether you've ever costed the administrative, how much money you spend at central government, regional, local government levels to undertake these assessments compared to a much more straightforward individual assessment process. Because I suspect, well, I know from experience that the more complex hoops people have to jump through, the more difficult it is to get assistance. Actually, the more costly it is to provide because of all of the administrative, the staff, the systems, everything that goes into it. So I'd be very interested to know whether you've ever calculated how much it's costing you to run this very complex system compared to how much actually ends up in the hands of the people who need the support.
Well, perhaps I could add a few questions on my side in order to cover the full range of issues concerning the Public Assistance Act. I would like to ask 3 questions in regard to the Public Assistance Act. The first one is, could you confirm the levels of assistance provided, the amount? I think I understood that it was 9,500 NTD per month as, you know, living assistance, but I may have misunderstood. I don't have the written figure. And how is that amount calculated? Is there a system of indexing, adjusting to the cost of living of the levels of public assistance? That's my first question. My second question is related to what our colleague Rosalie Noonan just mentioned concerning the persistence of pockets of poverty in the country despite the various social welfare laws that exist. I was struck myself by the very small number of individuals supported by the public assistance system. And I wonder whether there's any estimate of the non-take-up of social benefits by potential beneficiaries who may fear to claim support because of the potentially catastrophic consequences of being found to provide false information or to having hidden information from the authorities. And I refer to Article 9 of the Public Assistance Act that refers to the duty to provide real and actual information to the authorities under the Act. In many countries, when you have these harsh requirements and sanctions imposed on those who allegedly try to cheat the system, many people are discouraged. And the complexity of the rules may result in people fearing to ask support because they are not certain they qualify and they fear they will be accused of trying to fraud the system. That's my second question. The non-take-up of rights, the non-take-up of social benefits, given the potential consequences of being accused of providing false information. And then my third question relates to Article 5, paragraph 1b of the Act, which concerns people capable of working but unemployed. I read this a few times. I do not understand this clause in the English translation I have in front of me. And so I would like to seek clarification. If you are without a job and you have no unemployment benefits, but you are considered to be capable of working, what I read here is that for persons capable of working but unemployed, the calculation shall be based on base pay. In other terms, there's a presumption that if you are unemployed, you nevertheless have employment corresponding to the minimum wage. But that's a very bizarre fiction when actually you are trying to protect people who have no income, or at least who say they have no income because they cannot find a job. So my question is, what if you are in Taiwan, you fail to find a job, although you have, you're fully capable of working, but there's no job you can find. Maybe you're just not confident enough when interviewed by an employer. Maybe you are just too shy, whatever the reason. So that's my question. How should I interpret this Article 5, paragraph 1b of the Act? Thank you.
Or you don't want to take the job that undervalues. Yeah? You don't want to be underpaid rather than, not suitable job or not decent job in your judgment. In addition to what colleague Olivier de Schutter raised, I just also have some additional question before you provide answers. In your definition of lineal relatives, does it concern parents and children, or does it also include siblings, brothers and sisters, or fourth degree cousin. What is your definition of lineal relatives? Yeah. So you said that there is an exception of if they are married, then they are excluded, et cetera, et cetera. So what is the definition of linear relatives? And second, what is the proportion of one-person household in Taiwan? And out of one-person household in total, how many of those are over age 65? Older persons category. Because I don't find that from the core document regarding household composition. And nowadays, in many countries, there are many households of one person. You live alone, whether you are a young person or whether you are aged. That's a global phenomena. So, in order to figure out what is the composition of demographic household, thank you.
My colleague answered the question about concrete. And on behalf of the Ministry of Health and Welfare, well, what you are talking about is actually about modernization of our social assistance system. And actually, we have already prepared a draft. And we are now, we are just sent to the administrative yuan, and well, we hope, in the hope that the Parliament can approve or can discuss it as soon as possible. This is our principle. So here you are talking about, traditionally we have our traditional social assistance system. And that's true, as Mr. Deschutes has claimed. Well, in our paragraph 5, it has been taken for granted if one has been claimed unemployed. Well, I think it's because of this traditional administrative laziness, it will be calculated as a so-called minimum wage. But in our new draft, now we have revised. And later, now I can tell you. Well, first of all, we will ask you to say some a number, and then we will correct it according to our labor insurance, etc., and data bank, and to check if it's real or not. Okay, so this is some of our measurement to correct this problem. So point 1 and point 2, Mr. Nolan and Dr. Xu has talked about has discussed how to calculate this household. Well, traditionally, is a household as a unit, but I know in the UK or maybe in Germany, now it has been considered the social assistance applicant should be individual based. Now, I will say it is still quite controversial because in Taiwan, we are very, very the family still is still regarded as an important vital role for sharing, But now we are, frankly speaking, we are considering about this possibility. So it comes then to your question: who should be count into this household? And later, my colleague will answer you. But if I am correct, now the single family, I think is 18.9%. 18. But later I will I have to check. And for the elderly is about 15. But later I will, if I'm correct in my brain. But later I will respond to you. The second point, and the third is in Taiwan, where you have administrative costs. I personally recognize, because previously I'm also the Director General at the Taichung City Government. I have the experience. That's true. The administrative cost is surprisingly high. Because in Taiwan we have to calculate. First of all, your real estate, your house, and then your income, and then if you are a worker, you are working population, you will be counted as a minimum wage. So, I mean, this total calculation is as a means test is surprisingly high. So we are also trying to, now we are in the era of AI, right? So we try to minimize this problem of administrative costs through some technical solution. Okay, so now I ask my colleague, yeah, please. 有关于那个家户的那个认定。
For the definition of households. I need to check the numbers in terms of the amount. So the chair asked about the definition of linear relatives, and siblings do not count because siblings are not, like they don't fit the definition of linear. If the siblings use the applicant to, in their tax filing, say that they support this applicant, in that case, the siblings need to be responsible for this because they file tax already. And for Taiwan, in terms of the application for public assistance, what is the attitude of the people in Taiwan? Are they afraid of doing so, or are they, they prefer to do the application? So I used to work in the central government and also local government. And, when we work in the government, of course, we want the procedure to be as easy as possible. But, the objective information we can receive is very limited. So we have to do it in the hard way. We have to visit the household. We have to collect all possible information to do a more comprehensive review. But it's very difficult to get objective information or data about the applicant. How come it is very important to evaluate the eligibility of the applicant? We can see the applicant does not receive just over $9,000. For people in New Taipei City, at most they can receive more than 20,000 New Taiwan dollars, 20744, because every city and the county have different historical background. So in terms of benefits provided by the government, it only increasing, not decreasing. Like our social affair administration said, these different assistance, these different stipends can be, stacked up, can be put together as long as, the total amount doesn't exceed the minimum wage. And indeed, for low-income family or middle to low-income family, do not always, receive a lot of monetary assistance. But we can see people in Taipei City receive more. And then we have done our review for low to middle income family in Taiwan. There are actually more than 200 requirements in terms of their eligibility. For me, I do not wish to see this. For me, I have to evaluate the eligibility very carefully. And for other government, agencies, they want to streamline, they want to simplify the requirements. So they will just follow my decision in terms of eligibility. So because this will affect, how much money they pay for education or how much benefits they can get for housing. All kinds of benefits actually depend upon whether this person is qualified for low-income family. So if this person is indeed a low-income person, then this person can receive this different kind of assistance. But that means my job is very important. I'm under this immense pressure. And this time for the amendment for the review, I hope that in the future the central government can have a consistent way, consistent reference, so that it will be easier for counties and cities for implementation. And are people afraid of applying this kind of subsidies? Like I said, there are so many different requirements for the application. So once a person is qualified, then it's going to help the individual, the family a lot. But however, there are some people who are concerned about how other people look at them. If they are, defined as a low-income family, they're afraid of being labeled as poor. So maybe some of them do not have the courage to apply for public assistance. So in our amendment, we can see in Article 9, subparagraph 1, in the Public Assistance Act, talking about if educators, police and social workers doing their work discover there are people in need, they need to inform the city and the city government and the county governments, because we have more than 150 social welfare service centers who serve vulnerable, disadvantaged people in the community. So the service center will interview and help these people to make applications. So these people do not have the courage, or they worry about people being labeled. And we have this reporting mechanism to help these people in need to make applications. And for the third question about people who are capable of working but who are unemployed in terms of the calculation of their wage. Like I say, for our imputed income system, how come we have to have this imputed income system? So the Public Assistance Act was passed in 1980. And for Taiwan, because Taiwan's social policies have been improving. So later on, we have our Social Insurance Act. So for our employment and our labor policies in the social policies as a whole, the employment agency and the labor agencies have become independent. And then we have our social insurance system. We have our unemployment welfare system. In the past, people could only rely on public assistance. But later on, we have more different types of insurance. For example, unemployed can seek help from the Employment Insurance Act and Employment Service Act. So like I say, social insurance is the main pillar, and the social stipend is the second pillar, and the public assistance is the last pillar.
The one-person household in Taiwan is 36%. And for the elderly is 23.3. Okay.
That's about the figure, because I think in my country it's about 32%, one-person household around that time. It might have increased. Yeah. But do you have any follow-up questions?
Many thanks for these very useful answers. And of course, I personally would welcome these amendments to the Public Assistance Act, which seem to be bringing about quite a few important improvements. You were not able, Madam, to provide information about the level of public assistance provided, because it differs from municipality to municipality. Which is one of the facets of the complexity of the system that is in place. But surely there are some directives given to municipalities as to how they should calculate the levels of public assistance they provide. What are those directives that they have, and to which extent are you confident that the levels provide for an adequate standard of living and are adapted to the changes in the cost of living?
Go ahead.
好。
For subsidies, stipends provided by cities and counties, we know that Taipei City, gives the most money. But we know that Taipei City is the richest city in Taiwan. And like I say, every city and county have their different historical contexts. And the amount only increases, never decreases. And Taipei City indeed, is richer. And for municipalities, for smaller cities and counties, they follow the central government standards. For local governments, if they have more money, if they want to give more, they can do so. So there is actually flexibility and space for them to provide more. So if there is inflation, things become more expensive. Will the stipends enough? You talk about adequate, standard of living. Like I said, public assistance is the last line of defense. So adequate standard of living, it doesn't equal the last defense. Adequate standard of living means that we still need to have some discussions and consensus as to what is adequate standard of living, because that is outside of my job responsibility. So I may not be able to answer fully. But when there is inflation, when things become more expensive, as I know, when the Department of Budget and Statistics saying that now the government has collected more tax, or when there is an inflation and the executive yuan will provide funding for low to middle income family. And then that means that these people will get more money from social stipends. Like I said, the almost 2 million people will receive more money in the stipends. So in addition to the money they already received, they will get this extra funding to respond to inflation. So in our Public Assistance Act, for poverty line, in terms of the lowest living standard, we review this poverty line, every year. And according to the Department of Budget and Statistics, we will see the latest median of disposable income to determine this lowest standard of living. So if there's an adjustment of the median disposable income, and then we will increase the lowest standard of living. So that means, we are in sync with inflation. And for the amendments, there are two things related to the CPI and inflation. In Article 4 of Public Assistance Act, we can see 60% of the median of disposable income. So 60% is a reference. And then we have 6 municipalities. They can make decisions themselves. Some of the municipalities will increase by $2,000. However, for some, cities and counties, who do not have so much money, they will probably increase by only 100 or 200. So it really depends on the adjustment of the median disposable income to adjust our lowest standard of living, so that we can really respond to the inflation of the time being. And in terms of, our eligibility, can we have more flexibility? Can we have loosened standard? Actually, in the law, we say that every 4 years, we need to review the money they claim. So we need to look at CPI to increase the stipends we provide. And for these amendments, including the Public Assistance Act and also the National Pension Act, and also the Farmer Stipend Act, which are sent to the Legislative Yuan already. So in addition to this review once every 4 years, we also have a medium, interim mechanism. So that means every 2 years, we will do a review. If the CPI increased by 3%, we will increase the amount upward. So this year, there are several acts which are going to respond to inflation. We hope that we can respond more quickly so we can meet people's demand.
Just a couple of things. Can I just ask, if inflation rises, I understand from what you said that where people are already receiving a form of social assistance, then that will, and a decision is made to increase it in terms of the CPI or whatever, that will be done automatically, right? But what about, but I thought you also said that there might be certain cases where people are receiving a particular kind of social assistance, not necessarily the social stipend, which is on top of, in particular situations. And do people need to apply separately for that? And if their circumstances deteriorate, is there some regular way of assessing that and just increasing the support they're getting? That's really my first question. Just, is there a further sort of loop to go through? But the other thing was that I really do want to emphasise that shifting away from a household aggregation, in particular shifting away from the means testing element, maybe limiting it to the actual income element, if you're still going to have a degree of household testing, that does not, but putting the primary focus on the individual does not mean that there are family members are, rejecting their responsibilities to provide what love and care they can and what support they can. But what we know is that there are family members who are providing that love and care, but they're not in an economic position where they can provide the full support for the person. And it's not, so I just, I think there's a sense that somehow making an individual assessment is rejecting, the family's natural love and support and wanting to do the best they can. It's just that some of us are just not in a position to do what's required. And that makes life really difficult for them too. So I just, in terms of the culture, because as far as I can see, people everywhere want to care for their family members who are struggling. But the extent to which they're able to will depend on their own circumstances. And I think particularly of elderly people trying to care for another elderly family member, but without a very, very significant amount of income and also with their own frailties.
Right. So I think I mentioned certain exclusions in special circumstances. So, for example, sometimes family members don't fulfill their support responsibility, and the applicant is therefore living in poverty. And social workers or local government can send people to visit the applicants, and such family members will be excluded. And I also mentioned earlier that if the household financial situation changes, now you asked whether a new application is needed if applicant's circumstances change. Now, for low income and medium low income households, they are of course first time applicants, and our law says that the government has to have regular checks on the household situation. So in practice, in the fourth quarter of every year, local governments will review the circumstances of the households. So maybe to see whether the demographic composition is still the same, whether there are people who no longer live there, whether there are people who have died. So the circumstances will be reviewed, and then if some people now have higher income, then maybe they will receive less support. But of course, there are also people who now have even less income. Then there will also be a response to that. So basically, there's an annual review. But in a very, very rare situation where there's absolutely no one else in the family that can support this applicant, then we'll also provide assistance that befits the person's situation. So we do have the review mechanism, and we also have social workers who can provide support.
Just one very short additional question. So how do you deal with the cases of homicide, family members killing the parent or the children, adult children, especially usually with disabilities, because the caregiving responsibility and the burden obligation is so heavy, and then you have no other way rather than killing your loved parent or spouse or child, adult child, yeah? So how do you deal with these cases? Do you provide more support? Because I think persons with disabilities, they are in tremendous need in terms of personal assistance. The caregiving family member, whether it's parent or child or spouse, really mesmerized and then really heavily stressed out. So how do you deal with that? Before the homicide, yeah?
I come from the Department of Long-Term Care of the Ministry of Health and Welfare. So we implemented Long-Term Care 2.0 for 9 years. Now we have Long-Term Care 3.0. It's a 10-year program. So it's basically to try to alleviate people's burden. So we provide, for example, community-based care service and other types of caregiving services. And among the services that we provide for family caregivers, they are covered by the program as well. So we have respite service available. And then we also have venues that provide support to caregivers. So, for example, mental support and so on. And we also have professionals who do family visitation. So usually we have a scale to see whether the family caregivers are already under tremendous stress. Now, and if we find that they are under a lot of stress, then we'll refer them to the support network for further assistance. I'm also from the Ministry of Health and Welfare, so just additional information. So you mentioned the tremendous stress faced by caregivers when they take care of disabled family members. Now, when people in Taiwan receive disability certificate, then we'll send social workers to the family to see what kind of need they have. And if we find that the burden of care is extremely high, then we'll have a social worker who will provide even more intensive support. In 2025, we find 6,134 families who are those who face a very high who face very high stress, and in this kind of situation, we provide respite service and other support.
If your service provided by the government is enough, then there would be no homicide, I guess. So that means that although you are trying very hard, still it's not enough. And I know that new immigrants, who do not have Taiwanese nationality are exempt, cannot receive that kind of long-term care service. So there are loopholes, that still need. So maybe government should try further, although trying very hard, I can understand. Yeah, so no follow-up questions so far. Yeah. So I think this concludes today's, oh yes.
Thanks so much for your, I would say, comment. And in our traditional social assistance system, I would say, probably we have two presumptions. The first one is if you are worker, if you are workforce, you will be, you will be taken for granted that as a minimum wage, and you will be also presumed that you have your family member to take care of you. But your question is, maybe they are not affordable for this care, and they are also not so. As the shooter has just pointed out, I'm a worker, but I cannot find a job. So just two presumptions might be illusions. So this is also the reason why we will try to modernize our social system, and in this new draft to tackle these two problems through many effective measures to minimize this gap. Okay, thank you.
We sincerely hope that this new amended draft Public Assistance Act should be finalized, and then once it will be sent to the Legislative Yuan, and then will be passed as soon as possible. Yep. All right. With this, I will conclude this afternoon's discussion on Articles 6, 7, 8, and 9. It is really fruitful that we have capable officials, from the Ministry of Labor, Ministry of Interior, Ministry of Agriculture, all the different ministries and different agencies, so that we could have a very constructive dialogue with you who are in charge of policy making, decision making, and then who have full knowledge about the situation. So we thank you very much for this very constructive dialogue. And we thank for your frankness and being straightforward. And we look forward to the remaining dialogue tomorrow at 8:30 like today. Thank you very much. 谢谢。很好。
次国家报告国际审查。
The third session with the NGO is now beginning. And the chair will determine who to answer first. Please pay attention to your speed for the interpreters. And please raise your hand before you speak and identify your organization. And at the end of your speech, please turn off your mic.
Thank you. Yeah. Good afternoon. Yeah, we'll have a 1 hour session with you. And if you are here in the morning, you would know how we will proceed with dialogue with you. So as we did in the morning, each of us, those of us who posed questions regarding Article 6, 7, 8, and 9, will ask you focused question. And you can give your feedback regarding government answer or whatever was lacking regarding specific points that would be raised by my colleagues. So I'll first give the floor to Mr. Jochen van Bernstorff about Article 6, right to work, and then maybe to Rosalind also, and then regarding Article 7 and 8, Mr. Olivier de Schutter will ask questions. And then regarding 9, it will be about Social Security as questions raised to the government. Two of the colleagues will ask questions. Okay, is that agreeable? All right. So, Jochen.
Thank you, Madam Chair. We had raised the issue of the exclusion of domestic workers from the Labor Standards Act, and the government had replied that it's not possible to include domestic workers in this legislation, and that they probably will, as I understood it at least, that they will continue to have extra regulation for domestic workers outside of the Labor Standard Act. At the same time, they said that they have a legislation, have prepared a legislation that will change the situation to a certain extent. So I would be interested in your reactions, how you assess the situation, the legislative proposals, etc., initiatives, and what to expect, perhaps, from the government.
Let me see how many of you will be providing feedback. Okay, so please go ahead. Okay, so after.
Okay.
Well, thank you for the question. That's a very important question. I am from Taiwan Association for Human Rights. My name is Shi Yixiang. So in this time in the COR, I hope that you can strongly suggest the government to incorporate ILO C-189 into the domestic law. So the MOHW has been postponing doing so. There's one expert review meeting, and having experts say that all the domestic laws actually comply with the ILO C-189. But actually that's ridiculous, because in the morning we heard about, they do not have the protection guarantee of minimum wage. So that is a violation of ILO C-189. So that's the first thing that the Taiwanese government needs to do. And secondly, for long-term care for the family employer, they expect the domestic worker to work 24/7. So that is a common phenomenon. And we know that these households need to have caregivers, but they shouldn't exploit the domestic workers. So in the morning, the government talked about using a dispatch and experimental way for institutions to dispatch workers. I think that is the right direction. But now still the employer pay for that. So this has been criticized by the civil societies. So like what mentioned in the COR, the long-term care system need to be integrated with the migrant worker system so that we can publicize, caregiving. So we can use institution to address the long-term care family burden and also to protect the labor rights of domestic workers. So the Ministry of Labor and Ministry of Health and Welfare need to work together. But unfortunately, these two ministries are not able to collaborate on this matter. And I hope that this time in the COR, I hope the IRC can make such suggestion. And the Ministry of Labor says that domestic workers were in the household of the employer so that, the government cannot intervene. But that is something that we cannot accept. For example, when we talk about prevention of domestic violence, Taiwan, in terms of the prevention of domestic violence, the government, the public power need to intervene to prevent domestic violence. How come when it comes to domestic workers, the government says that there's nothing we can do? So that is something not acceptable for us. So I hope that my explanation can allow you to understand the current situation.
Thank you. Please.
Good afternoon. I'm a representative from the New Vitality Independent Living. So the Ministry of Health and Welfare said that they already have a diverse program for caregiving, but it's actually not very accessible because disabled people still have to pay out of pocket, and also the service is only temporary, it's only short term, so that it doesn't really cover our needs, our daily needs, and also the costs are too high, especially for a lot of disabled people who don't have stable incomes. And like the previous speaker said, there was a pilot program for migrant workers working in a household. And the thing is, certain protection provided by the Labor Standard Act is still not available for the migrant workers, because Article 84-1 of the Act has the so-called responsibility system. And it says that through labor-employer negotiation, working hours can change. We think that this is unacceptable. And also, we think that caregiving for the disabled should be something that's public rather than left to the market mechanism.
Yeah. Anybody else? Okay.
Thank you, Chair. I come from a Covenants Watch. So I want to echo what the previous speakers mentioned. So we've been asking the government a lot of questions. In 2022, the Taiwan government raised the wage of domestic workers to 20,000, but at that time, the minimum wage for Taiwan under the Labor Standards Act was already 25,250. And currently, domestic workers' minimum wage is still lower than the minimum wage for the general public. And the Taiwan government has not yet responded to our question as to why domestic workers cannot receive the same level of minimum wage as other workers.
Article 6, right? Yeah.
Yeah.
About,
yes.
domestic workers.
OK，谢谢这个审查委员以及各位
Thank you, committee members, for your concerns. I'm Wei Yilong, and I come from the Chinese Human Rights Association. So regarding migrant domestic workers, now I think in any country, this group is vulnerable. If someone goes to another country to be a domestic worker, usually it's because they have problem earning a lot of money in their own country. So basically, they go to another country to work in order to earn more money. And if there are restrictions on the migrant workers' right to work, then is this also something that we have to think about, because this can be a violation of human rights as well? And also, why is it that the migrant domestic workers don't receive the same amount of wage as other workers? I think that's also a question that we need to ask.
Thank you. Yeah. Now, you want to add? Yes, on the fishing, yes.
Thank you very much for the helpful answers and information. Another point we raised in the afternoon was the problem of migrant workers in the distant water fishing industry, and we raised the problem of labor inspections on the ships, on the vessels. And the government said that it has increased the number of inspections to, I think, 60%, and that they are planning to increase it even further. And the government also said, or in the reports, it stated that I think only in 1% or 2% of the inspections they find a problem on board of the ship. So this looks a little bit like there is no problem anymore, and they do the inspections and everything is fine. I mean, they didn't say that, but in the report, the amount of sort of violations found is a very, very low number. So I would be curious to hear your opinion on that. Is it because the inspections, most of the inspections have been and still are announced, that they don't find violations of the standards, which are very low anyway, for migrant workers in terms of minimum pay, etc.? Or is it is the situation improving, or has it improved because of inspections over the last 2 or 3 years, and because of the action plan for the fisheries industry?
Okay, so how many of you would like to respond? Yes, you are the only one. Yeah.
Okay, 谢谢委员。
Thank you. I come from the Taiwan Association for Human Rights. So regarding labor inspections on board fishing vessels, the fisheries agency under the Ministry of Agriculture and also Ministry of Labor, the labor inspections take place only when the vessels are mooring in the port. So that's not the actual site of work. And the fisheries agency invites civil society to visit the vessels. But our experience is that the visits don't give you a glimpse into the real situation. Some visitors may have questionnaires and ask fishers questions, but often when the fishers answered questions, their employers are actually around them. So the foreign fishers, when they answer questions, I think there is some kind of pressure there. So it's difficult to know whether they are telling the truth. And also, distant water fishers are regulated by the fisheries agency. But labor inspections are carried out by the Ministry of Labor. Usually, it's the Ministry of Labor that carries out labor inspections. So we don't know whether the fisheries agency really has the expertise to carry out labor inspections themselves. The government said this morning that the inspection rate is around 50%, and they want to raise the ratio. But the thing is, currently only about 158 fishing vessels have Wi-Fi that is available to fishers. That means that less than 20% of the migrant fishers can use Wi-Fi to make complaints, for example. And you have to understand that usually the migrant fishers spend at least 9 months or even up to a year on sea, and they are not able to communicate with the outside world. So we need mandatory Wi-Fi installation to make Wi-Fi available to all fishers, so that when there are problems such as abuse or illness, or they are being owed wages, then they can make complaints through Wi-Fi immediately. I think that would be more effective than the labor inspections at ports. So we also hope that the committee members can include in the COR that there should be mandatory installation of Wi-Fi on fishing vessels.
Yeah, follow-up question. So there are no inspections on the sea. It's only when they are in the port. Yeah.
The fisheries agency or some companies will hire so-called marine observers, but the number is very small. And also, Taiwanese fishing vessels and vessels from other countries on board, there have been cases where observers just died in suspicious circumstances. And when there's violation, I think observers are really working in a very dangerous situation. So the fisheries agency does have fisheries observers, and in certain ports, for example, in Mauritius, they also have observers. But as I said, the number is very small. And distant water fishers, if they can join labor unions, and if labor unions can have a good partnership with, for example, ship owners and the captain, I think that would be more effective than labor inspections themselves.
I just wanted to ask a follow-up question. You mentioned that NGOs have been invited when some of the fishing boats are in port to go on board, and obviously in terms of what you can learn about the treatment of the fishes, of the semen. It's very limited in those circumstances. But I wondered about one of the issues that has come up in the past has been not only the poor treatment or even abusive treatment of the sailors, but also the very bad living conditions on the boat, on some boats. So I just wondered, have you observed, or members of your group observed when you've gone on board, the quality of the living conditions, and is that something at least that you can assess and report on and advocate for?
Thank you, Ms. Noonan, for the question. So during our visits, we can really go on board to see the living conditions of the migrant fishers. And in Taiwan, there are 3 types of fishing vessels, and the type that where abuse is more likely to happen is the longliners. So the longliners are smaller. That's why the accommodation space is very small, and the toilets are very dirty as well. And just a few days ago in Keelung, there was a foreign fisher who went to toilets on board the vessel, but he bumped his head and he fell overboard. And also the fishers, even when the vessel is mooring at port, they still have to live on board the vessels, even when there's a typhoon. So the fishers are required by the captain to basically take care of the vessels during typhoon weathers. That's the real situation. So the fisheries agency is really trying to make sure that the vessel specifications comply with C188. But to do that, more resources are needed. Certain fishing vessels cannot comply with current requirements. So we used to have more than 1,100 fishing vessels. Now it's around just over 900. So the industry itself is also facing some challenges. And I think the living conditions of fishers, of course, is also one challenge.
Investigation or research report issued by the agency on fisheries, regarding the living situation and then the working conditions, etc.
谢谢委员。
Thank you. So currently the reports, now our organization, the Taiwan Association for Human Rights, we have our own reports. Greenpeace and also other big organizations also have produced reports. We can also provide report to you. But these reports are coming from the civil society or international NGOs. We haven't seen any research reports from the government. But last month, we had the opportunity to meet with the Minister of Agriculture, and he also wanted to know the conditions of the fishers.
使用 Wi-Fi 的
including the accessibility to Wi-Fi. I think that will be the very first official report on that regard. So I think you made a very good suggestion, because the Taiwanese government require this systematic way to investigate the different needs of fishers.
Or research should be done by the government itself, but before that, if you can provide any additional information which is published in your report or peace vote, that would be helpful, I think.
And can I just raise, sort of supplementary to that? I mean, it's very, it's very usual when companies are asked, are expected to upgrade the working environment. It's very common for even the most successful, most profitable to plead poverty and say, oh, they can't afford it and whatever. And I mean, sometimes it is very expensive to upgrade, and you might be a small business and it's much more realistic to wait till, if you're a bus company, to wait till you're going to get new buses, and so you can't be necessarily expected to upgrade everything immediately, though cleanliness can be required. But I just wondered if, as part of your research, you had looked at the financial viability of the fleet of Taiwanese-owned ships, and whether they're are they owned by small owners, or are there big companies involved, or, just what the sort of financial sustainability, because it appears in most places that fishing is still very, except for the larger companies, fishing is still very profitable. Maybe not for the smaller ones.
Okay. 谢谢委员。
Well, thank you for the question. Indeed, many, distant vessels are owned by small companies, and they mainly located in southern part of Taiwan, in Donggang and Kaohsiung. And recently, for the Taiwan Association for Human Rights, we see that these fishers, the employer owe them money, owe them salary. For example, they have, waiting to be paid for 10 months or even 15 months, but they already have a very low salary. So it reflects the ability of the small company. It has to do with the oil price and the decreasing prices of fish. But there is also a large company called FCF in Taiwan. It's a notorious large company for seafood trading. Now, it has been disclosed to own a lot of fishing vessels which have forced labor situation. And so this kind of large company work with Chinese vessels or Taiwanese vessels, and they will try to get some certifications so that they can sell their catches to the EU or to the US. But this kind of large company is not trying to address the issue of forced labor on the front line. So that is a exploitative situation in the seafood supply chain in Taiwan. And we hope that the Fisheries Agency can help the small company facing difficulties in the industry. We hope that they can have collaboration with Walmart or Costco, these big channels. We hope that these big companies should, take their share of responsibility for forced labor. So I think it requires government's intervention to address this issue. Thank you.
Thank you. Because of time constraint, I think we should move to the next issue.
I should just report briefly that we did raise the issue of the situation of sex workers and the consequences for them of not being recognised formally in the labour market, having to pay taxes but not being eligible for any of the benefits that workers would normally be eligible for, or for housing assistance and so on, and also for often facing other forms of discrimination. The response that we got was actually that there was nobody really from the government at the time, this afternoon, available who was familiar with what, if anything, was being done with respect to addressing the discrimination faced by sex workers. So, and that we were promised with further information. So, just letting you know that. I mean, if anybody's got anything they want to say about it briefly, great. But we don't have something for you to respond to because it was sort of a non-answer. Although at least the government acknowledged that they would try and find out for us, and that was good.
So the government promised that they will send us more information by tomorrow. Yeah, so we will expect that we'll get more information regarding the situation of sex workers, regarding protection of their right to labor rights. Yeah, but do you want to add something?
So, I'm from the Taiwan Sex Industry and Workers' Rights Association. I'm the CEO, and we have 3 colleagues here. In the morning, we prepare a written report for your reference, because in the last session with ICCPR, and the chair said that we can provide written information for your reference. Whether domestic workers, distant water fishers, or sex workers, we can see they face a situation of a private place, and they rely on, for example, intermediary or a recruitment agency. So they are excluded from Labor Standard Act. And this time, IRC pays attention to the labor protection, medical services for sex workers. So we hope that we can, according to Article 6 to 7 of ICESCR, to supervise the government, because the government 15 years ago said that if the local government set up a specific, dedicated sex zone, then the sex workers and the consumers are deemed legal. But it's been more than 10 years, no local government is there to set up such a zone. So you may misunderstood that we are a very progressive. No. Actually, the central government, passed the ball, throw the ball to the local government, so the central government doesn't need to face this problem. So we support the stance of New Zealand and Belgium for decriminalization. Only when sex work is decriminalized, then sex workers have the opportunities to seek resources. For example, if they encounter violence or sexual harassment at work, they can seek assistance from the Ministry of Health and Welfare, from the police department. Although, sex workers are treated as part of the labor force said by the government, but it's our first time hearing the government saying that. And we don't hope our competent authority is the National Police Agency, because, the national police agencies normally just, trying to, control or supervise the sex workers. We hope that we can work with multiple ministries. For example, HOW, Ministry of Health and Welfare, can provide resources for consultation, for mental health, and also for sexual health. And also, the sex industry is very diversified. It's very different from regular labor conditions. So how can we better protect the frontline workers? So that really requires collaboration of multiple ministries. And for our organization, we hope to promote a dedicated, standalone act So we hope that first we can decriminalize sex work, and then this standalone act should involve frontline workers so that the government will know what is really needed by sex workers. So if the government, the central government and local government just throw the ball, to each other, then it's not going to have any concrete results. And lots of NGOs are paying attention to this. So we hope that government can see that as well.
Since the July examination is approaching by the CEDAW review committee, you can raise the issue there again. Yeah, of course we'll try to incorporate. But I read the Public Order Maintenance Act, and then it doesn't apply to the so-called customers, but only harass the sex workers. So. Okay, so we are finished with that. And then next, Article 7 on minimum wage, and then trade union rights, Article 8. Olivier, have any question to ask to NGOs? How many of you are working and then willing to respond regarding Article 7 and 8?
Do we have any unions in the room?
No trade unions?
No.
Oh, okay. But Olivia, so you ask questions. There is one, yeah. But maybe wait until he asks a question.
Yeah. No, so I would be interested, of course, in your comments concerning the way the minimum wage is set and whether the level, which is today 29,500 new Taiwan dollars NTD is sufficient. We understand that the minimum wage has been regularly revised, and in fact that the increases have been more significant even than inflation. But is the level sufficient in your view? And to which extent do you see the constraints of export competitiveness and attractiveness to investors as obstacles to raising the minimum wage in the minimum wage deliberation committee set up by the minimum wage law of 2024? That would be, I suppose, the key questions you would like to address under Article 7.
Anybody willing to? So 1, 2, 3. Okay, yeah, you go ahead.
Thank you, committee members. I want to first respond to Article 7 regarding workplace discrimination. And I come from the Taiwan Alliance to Promote Civil Partnership Rights. And previously you actually asked about the rights of transgender people, but the government didn't respond directly. And for transgender people, very often the challenges encountered at workplace include the use of bathrooms or also uniforms, and sometimes the workers will be forced to come out to their colleagues. And there are also transgender people who are terminated because the employers don't like their sexual identity. And in fact, all these cases can be dealt with in Taiwan's current regulation. But a lot of these things are still individual cases. There's no systematic way to deal with the problem. And also the government doesn't have comprehensive statistics regarding discrimination against transgender people. And among the people who came to us for assistance, many of them have intersectional issues. For example, some are transgender and also disabled. 69% of the people have intersectional needs. But often in Taiwan, these different intersectionalities are not taken into account in a comprehensive way. So, for example, in difficulty finding work can have to do with the fact that they are transgender or the fact that they are disabled. So we suggest that the government should enhance measures to empower people facing intersectional discrimination.
Thank you. Next.
好，我的代表单位是台湾。
Hi, I also have my colleague here. And regarding minimum wage, I think there are two aspects that I can talk about. So in Taiwan, we do have the Minimum Wage Act, but it's actually very new. Previously, it was the government that controlled the minimum wage level. And that control went on for 10 years. And there were also a situation where a review committee decided on a certain level of minimum wage, but the Executive Yuan didn't approve of it. So the Minimum Wage Act, I think, is a progress. But does the minimum wage really provide decent living conditions? Now, in the morning, the government mentioned the CPI, but the CPI, in fact, takes into account many different aspects. So, for example, there's food, there's also shelter. But if you have many different factors in the CPI, sometimes all these different areas will balance each other out. So we believe that the minimum wage setting, while it should be linked to CPI, we should focus more on the CPI indices that are the CPI elements that are more life-related. And also, from 2021 to now, there are still more than 860 cases where Taiwanese companies are not paying the minimum wage. So even if the law is there, there are still many companies that are not paying a minimum wage. So we believe that this is an issue that involves many different aspects. So the contents of the minimum wage and also enforcement is important. So even if the minimum wage number itself is higher, that doesn't mean that everyone can benefit from it. So just to reiterate, I'm from the Taiwan Labor Front.
Do you want to add anything, or just because you are from the same organization?
Yes, 是的，这边有
Yes, I would like to add 2 points. First of all, the CPI is what the government uses to set minimum wage. But in July, when a review committee is being convened, we see that representatives from different sectors or different agencies would actually come up with figures. For example, in January, the Premier already said that the minimum wage this year will be raised to 30,000. So whether the figure is really a calculation of the CPI or it's actually artificially determined, I think it's difficult to say. And also, you mentioned whether the minimum wage can help Taiwanese businesses or investment. Now, in Taiwan, a lot of companies want to cut their personnel costs. So when they only use minimum wage to try to recruit people, very often they don't find anyone. So some of these some of these companies would lobby the government to open Taiwan to migrant workers. So this can become a vicious cycle. Now, if the minimum wage is raised, when people can earn a decent wage, when the people of Taiwan can work, I think this will actually help with the overall competitiveness of Taiwanese companies.
Yeah, because we have 2 more articles to cover. Just 1 minute, please.
Hi, I come from the Taiwan Association for Human Rights. So asylum seekers in Taiwan often are forced to do informal work, and sometimes employers pay them less. Employers might say that if I hire you, I will be penalized by the government, so I'll pay you less in case I'm fined by the government. But asylum seekers cannot go to the government for remedy because they are worried that they can be deported by the immigration agency. And many of these asylum seekers also work in, for example, the manufacturing sector or construction sector, but they don't have any health insurance or disaster insurance or injury insurance. And in fact, regarding the time needed for the government to review asylum seekers' applications, the longest was 30 months. The shortest was 22 months. That means that during this period, they couldn't work. And a lot of these people's applications were actually rejected. And in fact, the Taiwanese government didn't give residency to any asylum seekers from outside of China, Hong Kong, and Macau. And the government actually mentioned that they would give the list of asylum seekers to local governments. And if local governments find that they are working illegally, then they can be exempt from penalty. But that doesn't really resolve the problem. So, and also, the central government only provides guidelines to local governments. It's the local governments that decide what to do, so they have their own discretion. But that also means that different local governments may also do things differently. And also, a previous government representative said that asylum seekers may be spies, so there can be national security issues. But out of the 70 asylum seekers, about 90%, the asylum seekers who are not Chinese, Hong Kong, or Macau people, 90% are Burmese people living in Burmese people in Taiwan. So there's no sign that they are spies. And sometimes there are also cases where assistance is being provided. But in 2023, before 2023, Taiwan didn't issue any documents to asylum seekers coming outside of China, Hong Kong, and Macau. And basically, from 2023, there's no issuance of such documents to any asylum seekers.
We only have 9 minutes to cover Article 8 and 9. So, Olivier, do you have anything, question regarding trade union rights?
In fact, Madam Chair, with respect, there is one question I would like to raise very briefly under Article 8. But I would like to have one follow-up question to the unions concerning the minimum wage issue under Article 7. You mentioned that a large number of employers were not complying with this legislation. Why is that? What is the source of that impunity? Is it because labor inspectorates are understaffed? Is it because of corruption? Is it because of an implicit complicity of the government fearing that if wages go up, Taiwan would be less interesting to foreign investors? What is the reason?
Right, so regarding this question, I think, of course, if there's a violation of the Minimum Wage Act, there's a fine. But sometimes companies would rather pay a fine. So currently, the law doesn't have any provisions to stop these companies. As far as I know, in France, if employers consistently violate such law, then there can be criminal liability. But not in Taiwan. Some companies would rather pay fines to the government. And also, the minimum wage in Taiwan has been suppressed for a long time. And also, we have a lot of labor laws. But in Taiwan, most of the companies are small and medium-sized enterprises. So in terms of law compliance, they actually don't have a very good record. And also, this also shows that we have a shortage of labor inspectors. And that means that a lot of the violations are not found. So it's a vicious cycle.
Thank you very much for this very useful answer. On Article 8 concerning union rights, the question which I would like to hear about is the question of the approval of collective agreements when collective agreements are negotiated in the public sector for public enterprises. Article 10, paragraph 2 of the Collective Agreements Act provides that the collective agreement will not be approved if the superior authority, meaning the ministry in charge, does not approve of this. We are told, on the one hand, that this has not happened in recent years. On the other hand, there is information from the Taiwan Labor Front that such instances did occur, albeit quite exceptionally. What are your comments on this?
Would you like to react? Yes, please.
I come from Taiwan Labor Front. I actually wrote on this. So it actually went on like this. The National Donghua University and the Taiwan Higher Education Association signed a collective agreement, and the agreement was sent to the Ministry of Education. And the Ministry of Education said that the evaluation system for teachers is in violation of the University Act. It's because of this that the agreement wasn't approved. But the thing is, the superior competent authority can broaden the legal interpretation. And the law doesn't say when the competent authority has to give approval. So sometimes the competent agency can just basically delay. So statistically, it doesn't look like the competent authority is rejecting the agreement.
Okay, yeah, thanks. We have only 4 minutes left for this important question about Social Security. Is it concerning Article 9? Okay. Would you like to ask a question?
Where to start? Yes. So, well, we had quite a lengthy discussion about Social Security, which we got a lot of information. But basically, two issues emerged quite strongly. One was the lack of adequate support for people with disabilities if they're to be able to participate more fully in society. And the second was the continuing complex administrative nightmare that is the aggregated household calculations that underpin how much someone can get in social assistance. That's a very brief summary of a very long discussion, but we would really like to hear any additional, we had some very, very good submissions which enabled us to pursue questioning of the government, but any comments you've got?
Okay. 谢谢，我是。
Thank you. I'm from the Chinese Human Rights Association. I'm the CEO. I want to thank you for your concern over Taiwan's, social insurance. I want to talk about two things. First, by the end of 2023, there was a 1-year-old boy named Kai Kai. Well, his incident caused a lot of concern in Taiwan. This was a 1.5-year-old boy who was abused to death, and the social worker during visits was deemed to fail her responsibilities. She failed to do her job well. And this social worker is punished with 2-year sentence. And the nanny is sentenced to 18 years in prison. And now the case is still in court proceedings. So the Kai Kai case shows that Taiwan is not fulfilling the protection over minors, although there are some foster and visits mechanism. However, in terms of implementation, there are still a lot of gaps. In terms of the abuse of children, minors, there are no very good regulations. So after the case happened, there's a lot of responses from the society. So this is a case of a child being abused to death. Some people try to use politics to mislead the public opinions. People say that this has something to do with the cognitive warfare from China. But actually, it's a very ridiculous interpretation because this is simply about how to better protect minors. Second, I want to talk about long-term care. Taiwan is an aged society. So we can see the long-term care homicides. We can see a lot of cases. We can see, caregivers kill the care receivers. And after they commit homicide, they surrender themselves and they are litigated. And recently, there are 62 long-term care-related homicides. So there are 8.8 cases happening every year. 40% happen when parents kill their children because they are worried about what will happen to their children after the parents pass away. So how is the government going to provide effective ways to protect the people receiving care so that we can prevent homicide-related homicides from happening again? So I think this is something that we want to call to your attention. So because it has to do with Article 9 of ICESCR. Thank you.
We'll have I was just informed that we have to finish exactly by at least 6:30. So 5 more minutes probably, because we have to move to other space. So 1, 2, 3, 4, 5, but very, very short, please. And don't duplicate. 6. Right, in that order,
I'm from Taiwan Labor Front. So I want to clarify something. First, the government said that in terms of the care of family, the government said that this is a consensus of the society. Actually, we have conducted a survey. Actually, 42.2% of people say that they do not want to cause burden to their families. And 65% of people think that the government should take half of the responsibility. So that is not a consensus of the people in Taiwan. The government should shoulder more responsibilities. Secondly, the reviewer discussing with the government saying that they're afraid of making the applications. So for the recent years, we can see the passing rate. Actually, 49.3% failed their applications. Only half of them are able to be eligible. So the government doesn't tell us why half of the applicants fail. So this is hidden information. So people try to reach out for help, but they couldn't get help. And secondly, in terms of work wages. So in Taiwan, if I want to calculate you an unemployed person, and then the government use minimum wage, but minimum wage should reflect CPI, labor productivity, and inflation. However, the government use minimum wage to calculate whether a family can be met with their basic living standard. But the government does not want to change this indicator. We know that in their amendment, they still keep the idea of using minimum wage for calculation. So we have been waiting for 3 years. So I don't know, maybe next time when we meet again, so we wonder whether there'll be any progress for this draft. So in your COR this year, please talk about this again so that these kind of indicators can be removed. I want to propose two things. First, from the response of MOHW, they talk about, family mutual support and the social insurance should take precedence. However, now the job and the family structure are getting unstable, so that we really need to get more support from public assistance. So I hope that you can include that in your COR. And the MOHW talk about the poverty line. They say 60% of the median disposable income is the definition for poverty line in the Public Assistance Act. It's the same as EU countries. However, when they talk about poverty rate, they use the OECD standards. But the OECD their standard is 50% of the median disposable income. So that means they underestimate the poverty population in Taiwan. So if you look at Taiwan's GDP and economic development, we should use the EU standards. So 60% of the median of the disposable income, we will have our poverty population of 12%. However, the Public Assistance Act only covered 2%, so there's still a big gap.
That side? No? Yes. Briefly.
Thank you. I will be very. I just want to raise one issue because I just want to add that for the asylum seekers and refugees in Taiwan, actually they are excluded from the national health insurance, because even if an asylum seeker successfully obtains asylum status, they still cannot benefit from the national health insurance, because under the current National Health Insurance Act, the asylum seekers and refugees are excluded. So even so they are sick, they are too afraid to go to the doctor because they cannot afford the medical bills. So I hope that you can add in the concluding remarks that the refugees and asylum seekers in Taiwan, they are excluded from the national health insurance. That's all I want to say. Thank you.
Thank you. And then to this side, you go first, and then there was somebody here first, and then you.
Thank you. The MOHW mentioned that they provide different services for people with disabilities, but actually difficult for them to access these services. And the coverage rate is very high. For example, 80% for long-term care services. I want to ask the reviewers that for the government to have the right evaluation and precise numbers, because the numbers from the government are very wrong. they mentioned they have a high administrative expenses. However, for personal assistance for 2024, there is a budget of more than 400 million new Taiwan dollars. However, for personal assistance, only a little bit more than 1,326 people are able to receive this service. So that means that there's 2 more administrative expenses than the real services being provided. So whether it's personal assistance, the government says that they are providing the assistance, but there are a lot of restrictions. For example, first we are not allowed to go out and use the services. They're provided only at home, and it's not provided 24/7. So they only provide services to medium or to lower level. However, the severe cases are not able to get services. So we hope that we can get enough budget. Sorry, I'm from the Xinlong Clubhouse. I live in Ankang community. Ankang community is a community for low-income households. We want to focus on poverty alleviation. Well, how should I put it? Not in addition to systems, I want to tell you about the situation that we encounter. I want to share a member in our clubhouse. This person has the working ability. He used to work as a security guard, but he wasn't able to get full-time job, and then he worked in the construction site because he didn't need to file taxes. This will not affect his eligibility for low-income family. It's not because he didn't want to do a decent job. It's because the system forced him to do so. Because his father is in nursing home, he has to pay 45,000 New Taiwan dollars a month. And because he is regarded as a low-income family, so he can get the money from the social bureau. However, if one day he is no longer eligible, he has to pay for it. So as long as he is no longer regarded poor, then he will not be able to get the subsidies. So that's why he is not willing to get a regular job. And lots of children from low-income family, after they graduate from school, they will work. However, their parents will ask them not to work, because once they started working, this will affect the eligibility, be regarded as a low-income family. So this will affect the tuition fee they pay for their siblings. So that means these children are not able to work regular jobs because they would not want to affect their family's eligibility. So they will work in informal economy. So that is a very painful thing. So we can see there is a 3-year timeline, and then after the buffer period, still people do not dare to get a regular job. So after the 3-year buffer period, if people is no longer deemed low income, then that means that they will not receive support. I myself have been working in a library for 6 years, and I also work as a visitor for our organization. Now, of course, I think a lot of people would like to do formal work, but the design of the system itself makes people reluctant to really rise out of poverty, because that means that they will actually face higher, heavier burden. So I think that the system itself has to change.
Sorry, but I think we have to close discussion today. And tomorrow, when we deal with Article 10, 11, and 12, under 11, we can also talk about poverty and adequate standard of living. So whatever issue you want to raise. Additionally, please, tomorrow when we have discussion after the dialogue with the government delegation, we will have also time for 1 hour with NGOs. Yeah. With this, we conclude today's discussion with you, and as always, we are grateful for all the information you provided, and thank you for your kindness and engagement with us. And also I thank to the interpreters as well as the sign interpreters, and hope to see you tomorrow in the morning. 谢谢。